Good afternoon, everyone, and welcome to the Appellate Division First Department. Before we start discussing the calendar call, I would like to welcome a group of students that we have here today from the Bronx Law, Government, and Social Justice High School in the Bronx. They are part of an judicial internship program, which was started in the Bronx by one of our newest judges, Justice Jeanette Rosado, and also by Justice Michael. Yes, you're back there, hi. And Justice Michael, who's a justice in the Bronx, is also just recently appointed to the Appellate Division First Department and will next month be joining us up here. So welcome all the students, and I hope you enjoy as much of the arguments that you're able to stay and listen to, and we all wish you very good luck in the program, and thank you for being here today. And thank you all for being here. So we do have about 6.5 hours of argument time requested, so I have to ask that you think about limiting the amount of time that you ask for argument so that we do not have to stay here until 8:30 tonight. I'm sure no one, including us, would be too happy about that. So remember, we've had your briefs and your record. We are familiar with the cases, and we just need you to hone in on the important issues. So let me call the calendar, and we'll see how that goes. Please rise when I call your case out, and the appellant and then the respondent can tell me how much time you would like to request. People versus Melvin Gidy.
On behalf of Mr. Gidy, 5 and 2, Your Honor.
Okay, and respondent?
5 minutes for respondent.
Thank you. 5, 2, and 5. Chihaley versus the MTA. Submitted. Administration for Children is submitted. Ogerto versus One Borum. Okay, so I'm just going to tell you, we are not going to sit and listen to 5 people say the same thing over and over. I'm sure you figured that out already. So One Borum, you're the, who represents? Okay, so how much time are you looking for? We could do 3 minutes. 3 minutes, and you want 1 for rebuttal? Yes. Okay, so that's good. So that's 3 and 1. Then I have, sorry, run out of, pencil broke. Then we have 3 other respondents, appellants, Nobel, Nordist, and Rock Group. So you're all asking for some time? So who's Noble? Okay, 2, and Nordist?
Nordist is here, good afternoon. I would say 3 minutes.
Okay, and Rock Group?
Your Honor, 3 minutes, please.
Okay, and then plaintiff? Is plaintiff here?
3 minutes, please, Your Honor.
Okay, so we'll see how that goes. Did you guys get that? Okay, good. All right, thank you all very much for your courtesy. Gamez versus, or Gamez, I'm sorry, I'm not probably pronouncing that right, versus Clarkson.
Calling request 5 and 2, Your Honor.
Where is the respondent? Not here. Would you still like to have a few minutes to argue for?
Can I just get 4 minutes?
You certainly could. No problem. And you are the appellant. Okay, thank you. People versus Jasmine Foy.
Yes, appellant request 5 and 2, Your Honor.
Okay, respondent. Okay, 5, 2, and 5. Ustage versus Board of Education. Okay, and respondent. Okay, and you are?
For defendant Lafia, 5 minutes, please.
Well, I'm not going to give you both 5. Okay, I'll give you 3. 5 and 2, and then 5, 3. Okay, Davidson versus Schubert Organization.
Balance 5 and 2, please.
Okay. Okay, thank you, counsel. 5, 2, and 3. Doe versus Archdiocese.
Yes, Your Honor, good afternoon. 5 and 2 for appellant.
You are that, okay, is the individual coming, lawyers come? Okay, so you want 5 and 2, is that what you said? Okay, respondent? Okay, 5, 2, and 3. Thank you all. People versus Carlos Cruz.
Responding request 5, Your Honor.
Okay, 5, 2, and 5. Grasiano versus Landmark Group.
Your Honor, 8 and 5.
Respondent? Okay, so I'm going to give you 7 and 2, and I'll give you 7. Thank you. Prismatic Development versus International Fidelity. Is there a respondent here? Oh, sorry. I'll give you 6 and 2, and I'll give you 2. Thank you. Miranda versus Dream Drive.
Respondent, 3 minutes?
The appellant's not coming, or
Your Honors have no questions on the papers I can submit.
does anyone have any questions? I think you're good. Thank you. All right, we'll mark that submitted. Lynch versus Board of Education.
Appellant, 5 and 3.
Okay, and Board of Education?
Board of Education requests 2 minutes.
Okay, and the co-defendant? 2 minutes, okay. 5 and 3, 2 and 2. Carney versus Metropolitan Transportation.
Appellant, 5, Your Honor.
Okay, there's no respondent arguing. Okay, I'll give you 5 minutes. People versus Modi. Respondent?
Respondent request 8.
Okay, I'll give you 7 and 2, and I'll give you 7. Ortega versus Skyworks is submitted, and Spruill versus City of New York is submitted. First case for argument, People versus Melvin Gidy. Good afternoon.
Good afternoon. Benjamin Rutkenbecker on behalf of Melvin Gidy. I'd like to use my time today on the Batson issue, but preliminarily I'll just note for your honors that there's a series of Second Amendment challenges before the Court of Appeals that should be decided any week now and may well be determinative of Mr. Gidy's claims.
So are you asking or suggesting that we might want to hold this in abeyance pending those determinations? We are familiar with that.
I am, Your Honor, and also just flagging the potential for post-argument submissions in this matter in light of any decision that will be rendered by the Court of Appeals.
Okay. All right, well, you can go on to your
Thank you.
point.
So moving on to the Batson issue, the court erred by summarily denying counsel's Batson challenge and failing to solicit from the prosecution race and gender neutral reasons for striking 2/3 of Black women jurors.
But you only mentioned just the number, no other information at the time you made your challenge, correct?
So that is correct, but it's important to really look at the record and begin with the court's decision. And so
But
counsel...
would it be fair to say, counsel, that really on appeal now, you've broadened the argument that you did not give a trial court a chance to rule on? Would that be fair to say?
I think it's important to clarify, there are things we point to that counsel did not to. That is correct. Those are, I feel, important color for your honors and could be considered in the interest of justice, but even to the extent that counsel made a timely Batson challenge, the court's decision here was erroneous. The court ruled that counsel had not met his minimal burden at Batson step 1 because counsel had failed to prove that, quote, the assistant district attorney has been striking only Black females at this time. And that is not the correct legal standard. After that, the argument was foreclosed. Counsel got his ruling and couldn't supplement the record with additional reasons, but we are simply asking for the very limited remedy here.
Why not? Why didn't counsel offer a proof about what else he would say concerning the strikes?
I don't know why counsel didn't do that. I'm not arguing that, of course, that would have been preferable had he done it, but even on the record that counsel made.
So on this record, what essentially what was said below was that there was a racial pattern. That's it. And in this instance, 4 out of 6 black women were removed. As my colleague suggested, is that in itself sufficient to sustain your burden in the first instance?
There is case law that we point to, the Jenkins case, as well as federal cases that hold that a pattern is sufficient. I can see that it's a close issue. There are also cases that say the opposite. But what's different here is that we have the court ruling, again, with the incorrect standard, saying that counsel had to have shown that only black jurors were being struck. That's legally incorrect. That's the decision we're challenging on appeal. And at that point, the issue was finalized. Counsel could not have supplemented the record. Though it is, of course, worth highlighting, as we do in our briefing, that there's really no question here.
Why couldn't he have supplemented the record? Why, for example, couldn't counsel have argued about the composition of the pool at that time? Because certainly counsel saw the pool and could make those broader arguments.
Sure. So to clarify, could counsel have done that? Perhaps so. Was he required to? No, the issue is preserved by the court's erroneous ruling here. Though it is worth Your Honor's consideration that on the record here, we know step 1 was satisfied. We know that the 4 jurors at issue each had pro-prosecution tendencies, and that's clearly enough to satisfy the burden here, even if Your Honors have paused that merely pointing to 2/3 of the eligible jurors being struck is not sufficient, although I submit that that should be concerning for this court. And really all we are asking here is for this to be remitted to the lower court, for the prosecution to have to proffer reasons, which they actually do in their briefing, for Mr. Gidy to be able to respond at step 3, and for this to be decided under the correct legal standard.
Correct me if I'm wrong. Among the 6, didn't your counsel below strike one of the black jurors?
He did, Your Honor.
Okay.
He did, and that's, again, in the Jenkins case, that's a relevant consideration. This would be perhaps a slam dunk if the prosecution had struck 6 out of 6, but it does not foreclose the claim at all that defense counsel struck 1 of the 6 jurors here.
Okay, thank you. You'll
Thank
have
you.
2 minutes on rebuttal.
Good afternoon, Your Honors. John Hughes for the People. I'd like to briefly address the Bruin issue here. Counsel is correct, obviously, that there are several Bruin cases currently pending before the Court of Appeals, and certainly the people would have no objection to holding off on issuing a decision until some of those decisions are issued, which may be quite soon, since those arguments were in early September. But then to turn to the Batson issue, here, first of all, just as a factual matter, the judge below made quite clear on the record that there were 7 black women in the veneer, not 6. So, although my adversary keeps saying 2/3, that's not quite right. The people did use 4 peremptory strikes on black women.
So there was arguably a pattern, right? The people strike 4 out of maybe 6 or 7 black women. Is that pattern sufficient to meet the burden in the first instance for you to have to come back?
No, Your Honor.
Why?
Well, the Court of Appeals has made very clear that in a case where you don't have, complete 100% exclusion, that generally speaking, a pure statistical and numerical argument usually needs some additional facts and circumstances to actually give rise to an inference of discrimination. And I think those additional facts and circumstances are especially important in a case like this one, where we're talking about a very, very small absolute number of people. Because we have a very small sample size, well, then these percentages just don't have a lot of statistical meaning, really. And also to turn to this case, People v. Jenkins, and specifically the People v. Jenkins from 1990. There were 2 cases called People v. Jenkins in the briefing, one from 94, one from 90. So this is the one from 1990. But I think in that case, that actually, I think helps our case more than it hurts it. Because there, the defense attorney did not rely only on numbers, but also pointed to some other facts and circumstances too. So in Jenkins, the people...
Well, were there any other circumstances here, for instance, that would have raised an inference of discriminatory purpose that the defendant could rely on in this case?
Well, I mean, there's no real a fixed list of things that these are the only things you can raise as facts and circumstances. I mean, some examples of things that someone could raise theoretically would be, if the prosecutor asked questions or made statements that demonstrated bias in some way, or if the prosecutor seemed to be excluding jurors who would appear to be favorable, or an argument that, hey, these two jurors were very similarly situated. You struck this one, but not that juror, and the only difference between them was, their race, their gender.
But none of that was raised in this case.
No, none, Your Honor. And the Court of Appeals has made very clear that, generally speaking, a numerical argument just by itself is not enough when you don't have complete exclusion. And finally, with respect to defense arguments about the standard here, I think if you look at the record, there was some initial maybe confusion and back and forth between the defense attorney and the judge about, are you saying they were striking only black women, and back and forth. But I think the defense counsel clarified the point that he was making. And I think, and also, I think ultimately there's really no indication that the judge was actually deciding this on the wrong standard. And if the court doesn't have any other questions, then we will rest on our brief and ask that you affirm.
Okay, thank you.
Thank you.
Thank you. There's absolutely no indication in the record that the judge was deciding this on the correct standard. The judge makes their reasoning clear, again, when they state that counsel needed to show only black jurors were being struck by the prosecution. To the extent there's clarification after that, the judge then asks counsel whether he is talking about jurors of color or black jurors. Counsel makes clear that he's talking about black women, and the judge simply says, "You've not made a prima facie case, we will move forward." The ruling was based on the incorrect legal standard, and the prosecution, of course, cannot justify that ruling because it is incorrect. And in addition, when the prosecution talks about the additional circumstances that can make out a Batson claim at step one, again, supposed to be a very minimal burden on the defense at that point, we should want the prosecution to have to provide an explanation for a pattern like this, 4 of 6 eligible jurors. And we know we have those circumstances here. So the preservation argument that the prosecution makes, it's not a case really where we have an underdeveloped record. We know from the record that of the 4 jurors, 3 of them have relatives who are in law enforcement. 1 of them was a victim of a crime. These are people who we would generally expect the prosecution not to be striking, and that is, all we're saying is that is worth further inquiry in this case. So if there are no further questions, we would ask that you dismiss for the reasons in point 1, Second Amendment arguments, and in the alternative, remit this case for fuller consideration of the Batson claim.
Thank you.
Thank you.
Both. Next case, Ogerto. So perhaps 2 of the appellants can sit here and yeah, right. Well, you're there'll always be somebody standing up, so you'll just switch around. Just make sure to introduce yourselves and tell us who you represent. Okay. Counsel for one borough. Your name?
Nicole Verzillo, Your Honor.
Okay. You may proceed.
I would just like to first start off by addressing the plaintiff's claims that are on appeal here today, and then I'll move on to the other claims for contractual indemnification from the other defendants here. The lower court erred in granting the plaintiff's summary judgment as to his Labor Law 240 claim because a flatbed truck does not constitute the type of gravity.
Counsel, isn't this a bed truck plus a great deal of stacking of construction materials? And haven't we found in that case that you can have a 240 sub 1 claim?
The difference between those cases and the case that we have here is a worker that's standing on top of materials that are loaded onto a flatbed truck does not exactly change the outcome here. Brownwell v. Blue Seal Feeds, Inc., 89 AD 3D of the 4th Department, holding that a fall from a rebar loaded onto a flatbed truck does not move this case from one of the ordinary dangers of construction to one involving the special risk protected by Labor Law 240 subsection 1. That case also cited a third department case of Berg v. Albany Ladder Co., citing that holding a
Counsel, what about Idona from the First Department and Phillips from the First Department?
Phillips and Idona that are cited in plaintiff's respondent's brief are factually distinguished from this case because those cases did not involve a trip and fall, but rather simply a fall from the materials. Plaintiff in this case admittedly tripped.
Isn't that, seems to me that's sort of a distinction without a difference. There was a fall here, a fall from a height, while the worker seems to be engaged in activity that's covered by the statute, no?
I think the main issue in this case that is different from the other cases is that the absence of a tie-off point here is a baseless presumption because the plaintiff testified that he would not, the work that he was performing would not have required a tie-off point.
Well, he's 14 feet high. He does have the harness on, correct?
Correct, but he had stated that he would not have the work, he did not believe that the work that he was requiring would ever require a tie-off point, and that I believe he testified that he had performed working at an elevated risk on this type of work before. He did not require a tie-off point then either. Moving on.
Was there a place that he could tie off on?
I'm sorry, what was that, Your Honor?
Was there a tie-off place on the Flatbrook truck? Was there any place where he could tie off?
I do not believe so, Your Honor. Moving on to Labor Law 241, subsection 6, the lower court erred in granting the plaintiff respondent summary judgment here on section 23-1.6, subsection B of the Industrial Code. Plaintiff tripped on the materials that he was standing on. He did not trip as a result of the lack of an anchor point or tie-off point. I would just like to move on quickly, if I could, to the contractual claims, just because I'm running out of time.
Sure. You actually ran out of time.
Yeah.
I'll give you an extra minute.
Thank you, Your Honor. Nordist, Noble, and Rock Group should all be contractually identifying One Borum here. There is a contract between One Borum and the initial construction manager for this contract, and then the contracts all run downward. They were contracts that were made between each other for demolition work, and then contracts that was made between the construction manager, the demolition contractor, and plaintiff's employer. That all require in the contract that the owner of the premises, which is One Borum, be contractually identified for any work arising out of. The only contract that has a negligence trigger is the contract that is between Noble. And Noble here, I believe, is negligent for a couple of reasons. First of all, Noble, sorry, give me 1 second.
Excuse me.
Go ahead.
There's no dispute, at the very least, among the statutory defendants that there's no Labor Law 200 case, correct?
That's correct.
Nobody challenging that. I mean, they're not negligent, correct?
Correct. So this is assuming that this,
So then,
this would be
so
just
then-
assuming,
assuming there's a negligent trigger,
right?
how would you, what would you base the contractual indemnification on? We would have to wait and see, right?
That's correct. This is assuming that the court finds that there is negligence here to an initial labor law case. If it does get past that, Noble and Nordist and Rock Group there's plenty of evidence in the record that they've all been negligent here, especially Nordist, who hired was the construction manager, who was the demolition contractor, who did not in fact have somebody on premises at the time during the work, and they were required to do so per the contract. And this
Aren't those just issues, just rank issues of fact for trial?
I don't think they're issues of fact here, Your Honor, because it's very clear from the record that they in fact did not have somebody on site, and they were required to do so based upon the language of the
Well, that's
contract.
a breach of contract.
It was a breach of contract, but also was an omission under the contract, under the arising out of clause. The clause states it's arising out of or in connection with the work or any admission of the contractor or the subcontractor. Not having somebody on site at the time was an admission. They were supposed to be there when the sidewalk bridges were being dismantled, and they were not.
Okay, you'll have a little time on rebuttal, thank you.
Thank you for your time.
Noble.
Your Honors, excuse me, Jessica Price for Noble Construction.
You're the GC, construction manager.
I was the CM. I'm going to go with construction manager.
Manager.
I had a contract with Nordist, who was the GC for the demolition and abatement phase. of
How
this-
are you any different than a GC in this case? So aren't you just functioning like a GC, but
A
you?
different name?
I was a construction manager, and I
I
facilitated.
understand you go by the name.
I
construction manager.
understand that, but I had one person on site. I did not perform any work. My contract was literally given to Nordist. Nordist did everything underneath my contract, including abiding by the sections that required, as council has referred to, the site safety personnel being present during the dismantling of the scaffold. That's Article 5.3.
So you're saying you should not even be a defendant in a labor law 241 case in this case? Is that what you're saying?
Exactly. My position is that not only was I not on site, I was off site 2 weeks before the accident happened, which the lower court deemed as part of their decision.
But under your contract, were you responsible for the installation, maintenance, removal of the sidewalk bridge?
I was initially, and then I subcontracted all of that work.
That's fine. That's fine.
But they were a GC, so anything that they didn't do is on them, and I would be entitled to contractual indemnification from Nordist based on their failure to provide those site safety personnel during the dismantling.
But really, the first question is how do we analyze you? Are you a construction manager and thus not liable under the labor law, or are you in effect the GC responsible overall for the installation, maintenance, and removal of the sidewalk bridge? And then, as you say, liability triggers down.
Well, that's what I think what my problem with the lower court's decision was. They didn't actually decide whether or not, they said I wasn't on site, but what was my duty? Something. I maybe should have been on site. No one, not any person that we deposed from one BORM or anyone else with knowledge of the contract could tell me what my obligation may have been after I left site 2 weeks before the accident. The court did find that I was not on site when the accident happened, equally found that Nordist wasn't on site when the accident happened. My position is that I'm not a GC, I wasn't a CM. At the time of the accident, the demolition and abatement was done. It's New York City, you don't get a letter saying, hey, thanks, great job, your work done is here, right? Instead, you get kind of stuck on these obligations, and while the court wants to hold me in on a contractual obligation that can't be articulated, it's simply unsupported by the record, and as you pointed out, Your Honor, to the extent that any obligation remained, it was the obligation of Nordist, and it should be contractual indemnification in favor of Noble in that direction. My time is up.
Okay, thank you. Nordist.
Good afternoon. May it please the court. My name is Lauren Bristol, and I represent Nordist in the case. First off, I'd just like to address the fact that summary judgment should have been granted to Nordist against Rock Group. That is a contract that required, according to the court, a showing of negligence. However, it's inconsistent for the court to make a determination on the facts of the case that Mr. Agurto was not provided with adequate safety equipment, that he was not provided with something that would have prevented his fall, and then in the same token say that negligence had not been shown in this case. The only ones on premises at the time were Rock Group and MAGA. They were the only two entities there. They were the ones performing the work. And in fact, MAGA was the one who was the supervisor saying, this is how we're going to do it.
MAGA was plaintiff's employer, correct?
MAGA's plaintiff's employer, correct. And the supervisor is, so Rock Group has the truck, it's their flatbed truck, and it's Rock Group's all of their equipment, it's all their scaffolding equipment, and there's testimony from the plaintiff that somehow he was employed by Rock Group at one point, MAGA at another point. Needless to say, the way in which the material was loaded onto that flatbed truck, that's the issue of negligence in the case, and in fact, plaintiff said, I don't even know if there is a safety device that could have helped me in this case, because even though I'm wearing that harness, there was no place for me to lock off to. So it was, if there was negligence, as the court has shown that there is actually the safety device that's missing, then Nordis should have been entitled to summary judgment against Rock Group because Rock Group was the one who was negligent in deciding what was happening. In the same token, as you know, the plaintiff had not filed a notice of appeal in the case and has asked for reversal in terms of the 240 and 241-6 claims against Nordis. And I'd ask that, one, the court not consider that because it was not a part of the appeal, but secondarily, Nordis is not an agency of the owner. It's not the general contractor in the case. It's a subcontractor. It was in a bigger, this was a full redevelopment project at One Borum. The only thing we're doing at One Borum is the demolition. We're not doing anything else. And this project was going to continue after us. So we were just a subcontractor in that. And then finally, I just would like to address the fact that One Borum has sought both common law indemnification and contractual indemnification against Nordis, and they're not entitled to either. The common law indemnification would require a showing of negligence on the part of Nordis. Same with the contractual indemnification. The contract between Noble and the contract with One Borum required that if you're going to get indemnification, there must be a showing that the subcontractor was negligent. The undisputed facts here show that that we were not on premises. We left the premises on November 13th. We had records in the ordinary course of business showing that there were no employees as after November 13th and that we had completed our work in there. So accordingly, they shouldn't get entitled to it.
Okay, and thank you. Counsel for Rock Group, excuse me.
Good afternoon, Your Honors. May it please the court. My name is Brian Healy. I'm with Malaparo, Prisco, and Clauber. I'm here on behalf of Rock Group. Just preliminarily, I would like to point out that the lower court incorrectly dismissed Rock Group's counterclaims against One Borum and Nordest, even though we did clearly make arguments in the underlying papers, and that's referenced in the record on appeal. I'd like to move on to the indemnification issue, which is really, I think, probably the most contentious one. The Rock Group subcontract required a negligence trigger, and the court below specifically found that there was no evidence of negligence on behalf of Rock Group or on behalf of its subcontractor, MAGA. And the court determined that there were...
Was Rock Group at the site?
No, Rock Group was not at the site. Rock Group subcontracted to MAGA.
Only MAGA. It's your position that only MAGA was at the site.
That's correct, Your Honor. Yeah.
You didn't own the truck or anything, the flatbed truck or anything that was on the truck?
We may have supplied the truck, but there's no allegation that there was any defect in the truck or anything like that. There was the workers from MAGA were loading the scaffold onto the truck, and then that's when the accident occurred. We'd also like to mention that...
Shouldn't all those issues essentially get sort of sent down for trial in the third-party actions so we can figure out, or someone can figure out precisely who was on the site and what occurred at that time, and then the indemnification provisions fall into place?
I think that's absolutely correct, Your Honor. I think this is a situation where the trier of fact is going to need to determine who's responsible for what, and that's going to determine the indemnification obligations here. As the court below correctly found, that there are outstanding factual issues. There was a reference to undisputed proof that Nordest was no longer on site. In fact, I would submit that in fact is disputed, and we've made arguments in our brief, and it's contained in the record, that suggests that it's a factual issue, and that's something else that the court needs to, that the trier of fact needs to determine, because there's a partial indemnification clause as well as a complete indemnification clause, and if Nordest was responsible for any portion of negligence, then they would be responsible for a partial indemnification as well. That's something that needs to be determined by the trier of fact.
Just one minor point, maybe not so minor. The issue of procurement of insurance, that's really not in dispute. There was insurance purchase. The issue is whether there's coverage, correct?
That's correct, Your Honor. My understanding is there's a declaratory judgment action that's pending on that. Rock Group did, in fact, have an insurance policy.
But they didn't name one borrower, insurance
And they
company didn't
named,
name one borrower
and
because
they
of some
named
issue.
the appropriate parties, but my understanding is that that is currently being litigated in a declaratory judgment action.
Okay, thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Please support Anthony DiStefano for plaintiff respondent. This case is no different than Mio and Philip from this court. The fact that the plaintiff was standing stacked on materials on a
How
flat.
about the fact that he tripped over a plank when he bent down to pick up the belt? Does that take it out of the ambient of the statute?
No, Your Honor, it does not. Under this court's decision in Gomes versus Pearson, 159 ED 3rd 480, the plaintiff in that case, in fact, tripped over on a block and fell backward off of the material that he was standing on. And this court found that the fact that there was no tie-off for his harness was sufficient to establish the violation and approximate cause of the plaintiff's injury. So the fact that he tripped is of no moment in this case. As to
So we
Noble,
don't have, I'm sorry, so we don't have to reach, assuming we affirm the grant of partial summary judgment on liability for 241, we don't have to reach the 241-6 issue.
right, you would, I've seen decisions from this court where you said the fact that you grant 240, you don't even need to reach the 241 subsect, sure. As to Noble, once they were delegated the authority for the work, they could not, in fact, delegate that authority to their subcontractor.
Are they a GC or a construction manager?
According to One Borum, they were the GC. I mean, the title of the contract says construction manager, but the testimony from One Borum is they functioned as a GC. And again, under the Court of Appeals decision in Russin, once you undertake the authority to control the work, you cannot delegate that to you want to call them a subcontractor? Call them a subcontractor. It's irrelevant. This court's decision in White as well, where there was a prime contractor for the work, and this court said the fact that you undertook the obligation to perform the work makes you responsible under the labor law, and you cannot delegate that to your subcontractor. So for that reason, it should be affirmed as de novo as well. Unless the court has any other questions? Thank you very much.
And I gave One Borum a,
I'm going to waive my rebuttal.
okay. All right, well, thank you all. We'll take a look through this pile of papers and try to figure it out. Thank you. Next case for argument is Gamez. I gave you 4 minutes.
Yep. Good afternoon, Your Honors. May it please the Court, Brian Isaac. I represent the plaintiff appellant, as you know. My adversary is not here, so I'll try to truncate my argument. I have 3 basic arguments. The first is a procedural argument, the second is a comparative negligence argument, and the third is a 240 sub 1 argument. Let me deal with the procedural argument in 15 seconds. I don't think it's going to make a difference. I didn't do horribly in the case. I have summary judgment, but it's a little disconcerting to a litigant to lose a case before.
I guess they couldn't complain the judge waited too long to write this decision.
No, Judge Kapnick, you got me there. I can't say anything about that. So let me move on to the next one.
Okay, thank you.
With respect to the comparative negligence argument, I just don't see any comparative negligence here.
Well, didn't the plaintiff walk down the stairwell with both hands, one hand with the 80 pounds?
He did, and that's what, and
The other hand, I'm just,
It was a 4-foot level, correct?
right. So we couldn't reach the rail.
right. So he had a level in one hand, and he had the concrete 70 pounds in the other.
How big was the level, Counselor?
It was about 4 pounds, I think it was.
4 feet.
4 feet. I'm sorry. Yeah, 4 feet.
He's going down a staircase with concrete, and I think 80 to 90 pounds.
Like in a bucket, I guess?
It was,
80 to
I
90
thought it was
pounds.
70.
Okay?
Yeah.
And then the other hand, he has a level. Clearly, there's a problem on the staircase. He trips on it, and he can't reach. Isn't that at least sufficient for a jury to say that there's an issue of fact as to comparative, especially there's some suggestion that there's a hoist available too, correct?
So the answer to my question, obviously, is they're all points, but my answer would be no, because I don't think it's unusual for construction workers to carry things down the stairs, even when they're using two hands. And secondly, the entire premise of the defendant's argument, I mean, you saw the photos, they're from 979 to 981. This isn't the kind of defect that the Ramputi court was talking about, which was painted in red. This you can barely
No one
see.
says there's no, they were just pointing fingers at each
Correct.
other. You did it, you did it, you didn't do it.
And every single person said there that it was supposed to be covered with styrofoam. If you look at the plaintiff's testimony, he never said he wasn't being careful. He said he was looking forward. He said he was actually looking downward, but you would never expect
But if he has,
to have that.
if both his hands are full and he trips, then the natural reaction obviously is to reach for the railing. Well, if your hands are full and you're going downstairs, heavy construction materials, you can't reach for the railing and you fall down. Why shouldn't the jury consider whether there is, if any, culpability on the part of the
Judge
plaintiff?
Singh, my answer would be that that would presuppose that there was a defect there. In other words, there was no testimony that I read in this record, it's a giant record, as you know, where anybody said that carrying two things down the stairs was necessarily negligent. Nobody said that. There was no claim that that happened. And construction workers, I mean, take a look at your cases, usually dealing with 240, right? This is what happens. You're moving quickly, you're doing things quickly. If someone had said, look, don't do this, that's fine. But if you look at Mr. Mead's testimony, Mr. Mead says this wasn't something that was supposed to be expected. And in fact, the only reason that he didn't fall was because he actually knew that this was there based on his prior testimony. And if you look at Mr. Matthews' testimony at 1076 and 1077, he specifically said that that area was an area that you were supposed to testify. So my position is, yeah, you can make those arguments after the fact, and they're good arguments. I don't think those arguments were made as well by my adversaries as you made them, but I don't see any evidence there that it's improper to use two hands carrying something down.
Counsel,
The
I'm sorry, what is your response to the argument that that wasn't the only sole mean of access to and from his work area?
So that's on the 240 claim, and let me get to that. There is absolutely no question that the defendants cited to the correct testimony. There are tons of cases from this court saying, and tons of cases, not so many cases, but a fair number of cases from the Second Department that say the same thing. Can I just go a little bit further?
Yes.
I'm asking you to take this part of your decision from Ramirez against Scholes and extend it out. And now Ramirez was a case where summary judgment was denied, but I want to read what you said, because I agree with this. This is what you said. Quote, nevertheless, even if plaintiff had an alternative way to get to and from his work area, the stairs provided the most efficient means of access. That's my claim here. So let me give you my hypothetical, and then I'm going to sit down. Assume you have two identical twins on a construction site, and the construction site has two identical buildings. Assume that they're doing the same exact thing, they have the same exact accident on a stair at the same exact time, and they have the same injuries. The only difference is that in the first premise, there's only one available staircase because the other staircase is closed off, and in the second premise, they're both available. I don't see why plaintiff in one case shouldn't get 240 liability while the plaintiff in the other doesn't. To me, that doesn't make any sense since they're similarly situated, and the labor law should protect them both the same. Thanks for listening to me.
Thank you, Mr. Isaac. Have a nice afternoon. Next for argument, People versus Foy. Good afternoon.
Good afternoon, Your Honors. Will Page, Office of the Appellate Defender for Mr. Foy. This is a straightforward SORA appeal involving a miscalculation under the RAI and involving an abuse of discretion for not granting a downward departure. If the RAI had been properly tabulated, then Mr. Foy would have been a level 1. And what happened here was that there was not clear and convincing evidence in front of the SORA court to score him points under two categories. And I'll start with the acceptance of responsibility. The guidelines make clear that we're supposed to look to the most recent, genuine reflections of remorse. And the exhibits that were submitted to the SORA hearing showed that Mr. Foy had that very remorse. He in fact said things like, would the victims, how did they turn out after such a traumatic experience? Were they ever able to piece their lives back together? Would I ever be able to apologize to them? And would they ever forgive my actions? and inactions.
So when did this come? Wasn't there a time when, in fact, he did minimize his role in what occurred?
Yeah.
And isn't that something that can be taken into account at the time, actually, or closer to the time when the events occurred?
Well, I think that's actually not what the guidelines would have us do, Your Honor. And he was 19 at the time, and there may have certainly been minimization and concern that he'd been dragged into a very unfortunate situation and then made his own mistakes. But that was when he was 19. These are statements that were made after he had spent 2 decades in prison, and he'd had time to reflect and grow and think and become the man that he is today. And that's why the guidelines say that we focus on the most recent evidence, and that is this evidence that was submitted to the SORA court. And to Your Honor's point, even if there's some equivocation, then that's not clear and convincing evidence that he does not accept responsibility. And so those points should not have been scored. And so then in the second category of substance abuse, the guidelines also point out that we should consider, as an exception to that category, long periods of abstinence from
Of
substance
course, he
use.
was he was incarcerated for 20 years. So I mean, that period of time, hard to count that period of time to deal with how he's going to deal with it outside of prison. He spent half his life in prison.
It's absolutely true, Your Honor, that he was incarcerated and that he's been on post-release supervision. Nevertheless, people still manage to find ways to become intoxicated or to abuse substances in prison. That happens all the time. And I think there's the
Counsel,
additional...
under Watson, our case, shouldn't the history of substance abuse be measured as of the time of the offense under Watson?
Well, that's if we're not looking at a prolonged period of abstinence, and that's what we have in this case, where we have 2 decades plus where Mr. Foy has not touched anything. And I think the additional protective factor in this case, which shows why the RAI would overassess his risk if we were to give those points, is that his health mandates that he not use substances, right? His health was not great to begin with, but it has very much deteriorated since his time in prison, right? He's doubled in age. He now has a catheter implanted in his body so that he can have hemodialysis 3 times a week. And if he were to engage in substance abuse, it would be life-threatening for him. And so that's why those points should not have been assessed there. And when you take both of those out, then he's a 65, he's a level 1. But alternatively, if they're not taken out, then that's why this is a perfect case for a downward departure, because the RAI is overassessing him. Right, Mr. Foy, as I've already alluded to, doubled in age in prison. He had strong family support that he maintained. He participated in vocational programming. He participated earnestly in sex offender treatment. And because of his now debilitating medical condition, which requires hemodialysis 3 times a week, he is a very low risk of reoffense.
Do the mitigating factors here outweigh the aggravating factors? After all, this was a rape at gunpoint of a young stranger. Isn't that something that we should take into consideration as well?
I think that the nature of the offense, Your Honor, is well taken into consideration by his lengthy prison sentence. Mr. Foy spent, again, more than 2 decades in prison. I think we are here now, and what we were doing at the SORA hearing was considering his risk of reoffense, specifically sexual reoffense. And this was Mr. Foy's only criminal action of this variety ever, and it's really his only concerning criminal action ever. And he's not done anything since he's been released, and he's not going to. He's going to continue to go to hemodialysis and be the best person that he can be. And that's why the totality of the circumstances in this case militate in favor of a level 1. And I'll reserve the rest for rebuttal.
Okay, thank you, thank you.
Good afternoon, and may it please the court, Molly Morgan on behalf of respondent. The court providently exercised its discretion in adjudicating defendant a risk level 2 sexually violent offender, and also providently denied his downward departure request. First, with respect to the acceptance of responsibility points under Factor 12, I'd like to draw the court's attention to the fact that just 9 months before the SORA hearing, defendant wrote a letter, I think it was seeking release, and he still was minimizing his actions. He claimed to not fully remember what happened that night and seemingly lamenting the fact that he couldn't prevent or stop the victims from being hurt. I think that goes hand in hand with his initial repeated minimization of his actions. From the beginning, when he sat down and was interviewed by the assistant district attorney, he insisted that he wasn't there to take anything, that he was just talking to the victims. That's how he characterized his actions. He claimed that he could not do it to the victim, and he only admitted to the rape when the assistant district attorney asked him, but you did something to her, right? And then he finally admitted it. And then after going to trial and being found guilty by a jury, he denied his guilt in the
Counsel, despite
I'm sorry, go ahead.
all of that, the board still did not score him for that. The board gave an RAI of 80 rather than 90.
That's correct, Your Honor. But the SORA court here correctly assessed those additional points based on, I mean, especially that letter just a few months before the hearing. I think based on that, the court correctly determined that he was continuing to be evasive and claiming to not fully remember what happened. That's not a full acceptance of responsibility. So the court was well within its discretion to add those points. And, you know, even setting aside those points,
It still would have been a level 2.
Exactly, Your Honor. And there's truly no basis here to downward depart to a risk level 1 in light of the absolutely heinous nature of the crime. I'm sure I don't need to repeat.
Well, what about,
particulars.
as your adversary points out, I mean, his health situation is pretty dire, so the odds are he's not going to go back to presumably drinking and substance abuse because it may kill him.
Well, Your Honor, to that I would say, you know, I think he's unfortunately had these very serious medical issues his whole life, it sounds like, and it doesn't sound like it stopped him in the past. I understand his situation may have changed, but I don't think the court abused its discretion in that regard, because the guidelines specifically reserve discretion to the court, saying that it may choose to assess points if a defendant hasn't recently abused substances. And I think that makes sense, because the whole impetus of that guideline factor is to look to a defendant's history of abuse. We can't really fairly assess their current abuse, especially when they've been incarcerated for long periods of time. And again, otherwise, the assessment of points was well within the court's discretion. He characterized himself as an alcoholic to a doc's intake counselor. He said he started using marijuana and alcohol at a very young age and continued to use both until the offense. And he participated in substance abuse treatment. And finally, again, I would emphasize that the court didn't abuse its discretion in going down to a risk level 1 in light of the truly heinous nature of the crime and defendant's repeated attempts to minimize those actions. His risk of offense is high, and the harm would be great if he did reoffend. Unless the court has any further questions, we ask that you affirm.
Thank you.
I would just suggest that we look at Exhibit J in full, and Your Honors read it in full, and not cherry pick different sentences out of it. You know, it's a walkthrough by Mr. Foy of his own evolution from being 19 to being 40, and it's towards the end of that walkthrough that he discusses his remorse and his ongoing, basically, wishing that he could apologize to the victims in the case. And I think it's also worth noting, to Your Honor's point, that the people did not comply with the 10-day notice provisions here. And so when they sought those additional points under the acceptance of responsibility factor, they should not have been able to do so because it placed Mr. Foy in the untenable Hobson's choice of having to either request an adjournment and stay in prison longer or simply go forward. And so that's another reason that that category should not have been scored. And otherwise, I think all of this back and forth we've just discussed, that his debilitating medical condition, yes. Did he have it as a young person? Absolutely. It's just gotten worse, because that's what often happens with chronic illness. And that alone alters the totality of circumstances here. But all of the other evidence did as well. And that's why a level 1 would be appropriate for protecting the community and serving SORA's goals. Thank you, Your Honors.
Thank you. Thank you both. Next case for argument is Ustage versus Board of Education.
Good afternoon, Your Honors.
Good afternoon.
My name is France Luzars. I represent the plaintiff appellant, Jeffrey Ustage. This is a pretty straightforward appeal. We're appealing the decision of the lower court dismissing several of the claims that my client brought, specifically gender discrimination, direct discrimination by both the Board of Ed and defendant Sharon Lafia, and race discrimination, both direct with the Board of Ed Sharon Lafia, and vicarious liability as to the Board of Ed.
So your position essentially is that the plaintiff, by putting all this information before the principal as to the conduct of Lafia, that kind of actual notice made them directly liable, so as to warrant not dismissing the DOE complaint, correct?
That's correct. And further to that, the principal suspended him the next day based on a, well, we consider rather suspicious claim that he was looking at sexually explicit materials on his phone. And the suspension itself, he was suspended without pay for about 3 months.
Also, I thought that the trial judge denied DOE's motion with respect to gender discrimination.
With respect to,
Gender discrimination.
no,
Maybe I'm mistaken. In any way,
vicarious liability for gender discrimination, that was denied, but not direct liability.
I see. Okay. I think you made a very good case that it's sort of intersectional discrimination here, and that the race and sexual harassment that went on it's all of a whole. So it partakes both of racial discrimination and also gender discrimination.
That's correct, Your Honor. She wasn't just, Ms. Lafia was not just discriminating against Mr. Ustage as a man. She was specifically discriminating against him as a black man. And among her lascivious texts were references to his being a black man.
So with respect to her, Lafia, is that how you pronounce her name, Lafia?
I believe so.
Can her actions be imputed to the DOE? In other words, was she in a supervisory authority role sufficient for liability to attach through that theory?
We submit that she was, Your Honor. She was the classroom teacher. She was in charge of what happened in the classroom. She didn't have the ability to fire.
I was going to ask you that.
Hire or fire,
Right.
but she had supervisory responsibility over him.
Don't we need more? Isn't it? It's the ability to hire, ability to fire, which sets sort of the boundaries of that relationship.
Not exclusively, Your Honor. Having some supervisory responsibility, there was clearly a subordinate role. My client was clearly in a subordinate role in the classroom. His decisions could be countermanded and were countermanded by the classroom teacher, by Ms. Lafia.
But what authority did she have over the terms and conditions of plaintiff's employment?
Well, she had authority over the tasks he performed each day.
But is that enough? Is that enough? Don't the cases talk about something a little bit more? The terms, conditions, or privileges of his employment, rather than just the day-to-day activities that he does in her classroom?
I believe that we've alleged more. For example, in the situation where Mr. Ustage was one of the children, the students were calling him names, using slurs against him. Mr. Ustage wanted to punish this child, prevent him from going on a school trip, and Ms. Lafia countermanded that. So in that respect, she endorsed she didn't endorse the statements of the child, but it's a bit more than just supervisory, a bit more than just handing out tasks. She suffered Mr. Ustage to endure these racial slurs. Are there any other questions?
Why don't we hear from the respondents, and then you'll have a couple minutes for rebuttal. Thank you. You represent the Board of Education?
Good afternoon, Your Honors. Josh Liebman for Respondent, the New York City Department of Education. Much of this appeal is academic in light of Supreme Court's subsequent order. As we understand it, the only live issue as relates to DOE is the question of whether Ustage has adequately pleaded that Lafia's supervisor managed him for purposes of the city human rights law's vicarious liability. And for all the reasons in our brief, he did not. I want to address what Your Honor mentioned about what remains in the case versus what is not still in the case. Supreme Court dismissed Ustash's direct liability claims against DOE, but it's important to note that the vicarious liability claims, save for this one question of this specific theory under the city human rights law, as we understand it, remain live. The court below, the case is proceeding on the theory under the
Was the
state.
direct liability claims reinstated against DOE?
The direct liability claims, no, were not reinstated.
So that's really the issue then you should focus on.
Well, as we understand it, as narrowed by the briefs, the only issue that's presented here as relates to DOE is this question of managerial or supervisory authority under the city human rights law. And on that question, we think that the complaint's factual allegations make plain that there was not the type of boss-like supervisory managerial relationship between these two here. To the contrary, the complaint makes plain that for more than a calendar year, the two interacted with each other not at all in the workplace, and for a few months after that, the two were together in the classroom for only one
What
class
about the
period a
principal,
week.
Mr. Moda's behavior with respect to the complaints made by the plaintiff?
I'm sorry?
The principal, Mr. Moda?
Yes.
When the plaintiff first went to go see him in May 2018 and complained, he first of all tried to dissuade the plaintiff from bringing any kinds of action based on the sexual harassment by Ms. Latia alleged. But he also then he suspended the plaintiff briefly.
That's
right?
correct.
So
the
can't we
complaint.
draw an inference from that somehow of supervisory liability?
Well, it's important to note that the retaliation claims are fully live in this case, and that theory sounds, in our view, soundly
They were
retaliation.
reinstated subsequent to this order, correct?
Yeah, correct. Supreme Court subsequent order fully reinstated the retaliation claims. So on the theory that Your Honor is discussing, that Ustage went to the principal and said, I'm experiencing sexual harassment, and then he was the one who was punished, the parties are actively litigating below that retaliation theory. We submit to the court that that's something distinct from discrimination on the basis of race or gender. And as to what Your Honor mentioned, I would note only that according to the complaint's own allegations, Moda explained to Ustage that he could file an EEO complaint, and Ustage did so that very day. And as we note in a footnote to our brief, that ultimately did lead to disciplinary action against Lafia here, although that's a separate matter. But at bottom, the retaliation claims are proceeding, and the vicarious liability claims are proceeding, save for this narrow question about the existence of a managerial or supervisory relationship.
So why shouldn't the direct liability claim for discrimination proceed against DOE in these circumstances?
There are several independent reasons. First of all, Ustage has not identified.
First, you agree it's a relaxed pleading standard, correct?
There is a permissive pleading standard, of course, on a motion to dismiss. First of all, the complaint does not allege any, not even a single comparator under any direct discrimination theory, nor does the complaint allege any facts suggesting that a DOE administrator or representative harbored any animus towards Ustage on the basis of his race or gender. To the contrary, as we believe the appellant's brief makes clear, the main theory here is a retaliation theory, is that people responded to his complaint of sexual harassment by punishing him. We, of course, question the merits of that ultimately, but that claim is fully proceeding here.
So we should ignore the multiple messages, the explicit nature of the propositions, which was all shown to the DOE employee, the derogatory comments, which are arguably race-based in this case?
Well, the court shouldn't ignore it, and those theories are being litigated below. The only question
why not under direct liability? That's what why can't they be also addressed through that theory?
Well, they're being addressed insofar as the parties are exploring below whether DOE learned of this alleged harassment and failed to take corrective action. That theory is live in the case.
But I'm sorry, but that's totally distinct from retaliation, correct?
Correct. That would be
very distinct issue when the plaintiff went and showed all this stuff to the principal, pretty black and white in terms of the messages, et cetera, and an arguable acknowledgement. Yes, and it's clear that they're race and gender-based. So, and then did nothing but separately the next day on the alleged trumped-up issue of what he did wrong.
Yeah.
That can't stand alone?
Well, it is standing alone, and the parties are actively pursuing that. What that is a vicarious liability claim on the theory that DOE knew of the discrimination. But
I'm sorry, I don't mean to cut you off. Not vicarious. Vicarious means somebody over here did something and we're holding you responsible for that person's action. Here, the principal not personally reacting in a way that says, you know, this is outrageous, I got to do something. Isn't that a little different than vicarious liability?
May I, Your Honor? I see my time has expired.
Yes, go ahead
Thank
and
you.
please answer the question.
Well, according to the complaint's allegations, Moto was shown this information, told Ustage you can file an EEO complaint. That day, Ustage filed an EEO complaint, and ultimately discipline was imposed. These are the facts as the complaint itself sets forth. So action was taken. The disciplinary process that exists within DOE was
That
initiated.
sounds like a
and was
defense.
seen
That
through.
just sounds like something maybe on summary judgment. This is a motion to dismiss. You may be right on summary judgment, but why not allow a direct liability claim to proceed at this point on this theory?
Well, we're just taking the complaint's allegations, we're taking the complaint for what it says, and the complaint itself acknowledges that an EEO complaint was initiated immediately, and then that proceeding advanced. So for those, and I would just add again, as we understand it, the only arguments that are addressed to these direct liability claims in the appellant's brief are ones that sound in retaliation. So in our view, we believe that this issue is academic.
It can't be both? I mean, can't we look at it under both lenses?
I suppose it's possible, but for the reasons we've set forth, we just don't think there are enough allegations here to suggest that DOE itself, setting aside Lafia's alleged actions, for which there are active theories under which DOE might be held responsible, that DOE itself engaged in discrimination here in a direct manner. We believe that there is no viable claim there. So we ask that as to the managerial and supervisory issue, this court affirm and otherwise dismiss the appeal as academic as to DOE.
Thank you.
Thank you.
Counsel for Ms. Lafia.
Good afternoon, Your Honors. May it please the Court. My name is Corey Morris. I represent Sharon Lafia. Point 5. For us, this is all about point 5. That's the only point in the brief that relates to Sharon Lafia. It was never amended, and as my colleague has stated, it's moot if not academic. Fact of the matter is, they had every opportunity, and for that matter, there was motion practice, and over a year has elapsed, and quite a bit has elapsed, of which I could expound upon if Your Honors, if it may please the Court, but there was no appeal as to these allegations of petty slights and trivial inconveniencies, and that's the case law that we cite there. The allegations are disturbing. You'll note there's language like "we," but the responses are even more disturbing. This man was a convicted felon, somehow got himself into a school to represent special education students.
Counsel, stop that. I am not impressed by that latter statement.
Well, Your Honor, it's the truth. And look.
It's really, at issue are the comments, the text messages of your client, not whether or not he's a convicted felon, okay?
And what her authority was vis-a-vis him.
That's really the issue.
relevant
So focus
issue,
on the
counsel.
issue.
Okay. In their brief, they don't say he didn't do it. They say the allegation existed, that a student made it, that he was looking at inappropriate material, however we want to fashion it, and that's why he was disciplined. My client is a teacher in a special education setting. I don't know why they put him back in the classroom afterwards, but it certainly wasn't at my client's request. That's because she's a teacher. They're teachers together. It's not like the wait staff, might tell somebody to do something and therefore all the waiters can discipline, as my colleague elaborated in his brief. They exist on an equal plane. There's no supervisor authority. And the fact of the matter is it was a student, not the teacher, who initiated this complaint like other complaints that we know exist now. Text messages. My client's phone was taken by the DOE and copied. It didn't happen to Mr. Ustage, but certainly we would welcome that evidence because, again, the case continues.
Just as a parenthetical aside, did you represent your client below?
I did, with the exception of this.
So that retention was due to the fact that the DOE didn't want to give her a defense, correct?
In some regard, yes.
Okay, which means they believe there was misconduct.
I don't know how we could draw that connection, but well, I'd love to get them, right? 5 years later, I'd love to get
her text messages. Have you read her text messages?
We've tried to get them. They don't exist. But then again, we've sent the litigation hold notice out. We haven't gotten them. There was a disciplinary hearing, and I see my time is up. We still haven't gotten them. Through affirmative litigation at the court below and the federal court, we still haven't gotten them. Okay. If there's nothing else, I see.
Counsel, they weren't both teachers, correct? He was a paraprofessional and she was a teacher. That's two different roles, correct?
They're both teachers. They do different things. It's not like the math teacher could tell the science teacher, do this and that's it.
So is your position he's a teacher?
Is a form of teacher. And again, that's consistent throughout the papers and everything else. There's not a single allegation that makes her a supervisor, aside from the fact that I was harassed, she's a supervisor. She did this. That's it.
Okay, thank you.
Thank you.
Counsel, you have 2 minutes on rebuttal.
And, Your Honor, I'd like to waive my 2 minutes.
Okay.
Okay.
All right, thank you. Thank you all. The next case for argument is Davidson versus Schubert Organization.
Good afternoon, Your Honors. May it please the Court, Christopher Della Carpini for the appellants, Mr. and Mrs. Davidson. I'd like to begin with the sidewalk law issue. Justice Krauss below held that the LLC cannot be liable here under the sidewalk law because the alleged defect is supposedly a pedestrian ramp. I'm sure you're familiar with the photograph in the record at 7:05. Just to be clear, Justice Krauss held that this is a pedestrian ramp.
Right, it was a pedestrian ramp to nowhere, essentially, right? There was no building there.
To a boarded up wall, that's true. Although there's a building there. I mean, this thing, it's ramp shaped, right? I mean, it slopes.
Wasn't the testimony from the experts, both of the experts, I think, that at some time it was a ramp? Even if it does, I mean, it's obviously not a ramp to anywhere now, but at one point it was.
There is some evidence of record that somebody at some point used this, walked up this to get into the building. That's right. So why isn't this a pedestrian ramp? Because pedestrian ramp is a term of art. It's defined in the administrative code. And this court recognized that definition in the Ortiz decision, which we cited in our briefs. And that under that definition, a pedestrian ramp is a curb cut. It goes from the street to the sidewalk, not from the sidewalk to a building. That's the definition this court recognized in the administrative code and applied in the Ortiz decision. And under that definition, this doesn't qualify. Now, the LLC in their brief completely ignores that part of the Ortiz decision. They quote the part where they say, this court recognized that a pedestrian ramp is outside the ambit of the sidewalk law, but they ignore the definition of just what a pedestrian ramp is. But also, they offer...
Shouldn't, based on the competing opinions of the experts in this instance as to what this object is, shouldn't there be a trial so the jury can make a decision based on the evidence as to precisely what we have here?
No, Your Honor. First off, the defense expert opines that this is a pedestrian ramp under the Americans with Disabilities Act, not that he cites a single statute or regulation or anything to support that opinion. That's what he says. It's
so
a
that
basis.
goes to the weight of the opinion, correct?
No, there's absolutely no basis in the, it's a conclusory opinion. There's nothing
Also,
to
was the
support it.
plywood, let me ask you this, was the plywood up at the time of the accident? In other words, the barrier between, that cuts the ramp, whatever it is, in half, that was up at the time of the accident, right?
Yes, I believe it was.
Okay, so how could it be a ramp of any kind at that point? It doesn't lead anywhere.
Your Honor, I agree that it meets no practical definition of pedestrian ramp, but there is a
So
legal
it couldn't serve any American with a disability because it had no purpose. And it's the color of the sidewalk, right? It's the exact color of the sidewalk.
I'm sorry, what?
The color of the ramp, or whatever it was, looked like the same color as the sidewalk.
It sure looks like it to me, Your Honor. In the time I have left, I'd like to address the causation issue. Justice Krauss found that there's an issue of fact on causation, not because of anything the LLC put forth in the way of evidence, but because the Davidsons' only evidence of causation was their own eyewitness testimony. Well, this goes back to Hornbook summary judgment law. The Davidsons proved prima facie that this lump of cement caused her to fall. Ms. Davidson testified, she caught her foot on something.
The defendant seemed to harp on the fact that the husband, also a plaintiff, had testified differently than the affidavit that he put in. So did he do that?
I don't see that.
wasn't
What he
sure I saw that.
testifies to consistently I don't see them as conflicting, but let's assume that the affidavit is self-supporting and contradicting. We should just go with the testimony. I don't think they disagree, but just go on his testimony. What he testifies to is, I saw her start to fall, then I looked down, and then I see her foot dragging, being caught on the lump. She testifies it got caught on something. He testifies he sees it caught on the lump. That's prima facie proof. I don't think the affidavits disagree with that. If you want to disregard them, on the testimony alone, they have proved prima facie causation. And against that proof, the LLC offered absolutely nothing. They tried to suggest from a subsequent incident that Ms. Davidson has a tendency to have falls, whatever that means. But in that subsequent incident, she fell because of a defect in the walkway. That doesn't raise an issue of fact here as to causation. And then their expert again on it could only say that that her fall was caused by apparently an unfortunate misstep. That's not an opinion either. There's no basis there. That's speculation. If there are no questions, I'll wait for rebuttal.
Okay, thank you. We'll hear from respondent.
Good afternoon, Your Honors. May it please the court.
Good afternoon.
My name is John Marciliano. I'm with Mulholland, Minion, Davey, McNiff, and Byra. We represent the defendants' respondents. My argument is that there is a question of fact that was created by the difference in the affidavit submitted on behalf of the plaintiffs and the testimony that were given during the deposition. In the affidavit, Mr. Davidson, who was the only person who claims he saw what happened or knows what happened.
She fell. So
She fell.
But let's get to the primary issue here. Primary issue is, what is this blob of cement doing on a sidewalk? Is it a ramp? Is it something else? What is it?
Well, whatever it is a ramp. It's not a sidewalk flag. That's
Does it matter that it's not serving as a ramp at the time of the accident? Does that matter?
The defendant owned the premises at the time and could still have leased the premises at any time, and there would still be a requirement to have a ramp there in order for them to gain access to the retail establishment that would be there.
How do we know that? Is that in the record?
Because that's what's shown in the photographs that plaintiffs submitted going back to, I think it was 2011, 2012,
Right.
when Time Street.
It was there before, yeah.
Yes. Yes.
Wasn't there a store there before that sold souvenirs and things of that nature?
Yes, magazines, sweatshirts, things of that nature. And there was a difference in elevation between the floor of the store and the sidewalk outside.
That ramp served as an entrance into that store.
And hence the ramp. But the point is that in the affidavit, Mr. Davidson states he saw his wife strike the ramp. No, he didn't. The only time he saw anything was after she started to fall. And
I mean, the
by
whole
that
thing,
time, it
how
was already
long do you
done.
think it took her to fall? 2 seconds? I mean, he looked over when he saw her falling, he said, and he saw her feet, and he saw her fall down.
They also both made much of the fact that the sidewalk was crowded with pedestrians.
I'm sure it was. After the theater, Broadway is pretty crowded.
They didn't show that she tripped on anything else, including her own feet, the other pedestrians, a rock on. I'm not
Well, that's all.
speculating on that.
Well, I think you are, because there's nothing to show that except your testimony.
There's nothing to show what she fell on other than the testimony of the plaintiff said he didn't see anything until she was already in the act of falling.
Well, I mean, he wasn't going to stare at his wife the whole time they're walking down the street. They're from Omaha.
No,
Maybe
but he
somewhere
said-
else.
but he
They're
says-
looking at Louisiana. I keep saying Omaha.
But he says
But he
he
was
was-
looking at the boards, and
He was
he was
looking
walking
at the
along,
boards
and
to
she
his
fell.
right, which would take his view towards his wife on the right.
Counsel, cutting to the chase, on this record, there are dueling expert affidavits.
Yes.
Or affirmations, correct?
Yes.
And based on well-settled case law, when there are dueling affirmations of experts about what this ramp function was, the height differential, all that stuff, usually you go to trial on that, correct?
Yes.
Okay.
Thank you. Counsel, for the plaintiff, you have 2 minutes.
Thank you.
Thank you. Counsel, please sit down while he responds. No problem. Go ahead.
Thank you, Your Honors. On the issue of a disagreement or a contradiction between the affidavit and the testimony, I would simply say that I would direct the court to the record at 450 to 453 and compare that to the affidavit 699 to 700. I think he's consistent. As Mr. Davidson put it, we're talking about milliseconds. I don't think I saw the first contact. This is the
Let's assume we agree with you on that. Still, the issue, for me at least, as my colleague framed it, that we have two competing opinions as to what precisely this condition is, and should we accept your opinion that the defendant's expert is conclusory and grant summary judgment, or say, because there are dueling opinions, it's an issue of fact for the fact finder?
I agree that the experts certainly disagree. I don't think there is any proffered basis in the defense expert opinion to support his opinions. Good example of this is on
But you heard what your adversary said, that there was a store there. It was used for the store because there was a difference in elevation, and maybe the defendant didn't act reasonably, should have removed it once the store was boarded up. But those aren't those issues of fact to determine whether or not there was negligence, as opposed to us making that summary determination on a negligence case, which is rarely granted in these kinds of cases.
the experts are not experts on history. I don't think they should be credited as to the history of the building. That should be in the record. We have an architect and an engineer. Neither of them are historians who can opine with expertise about the history of this building.
Are you suggesting that there was no retail establishment there?
I don't think the purpose of this lump of cement matters here for liability. They had an obligation to keep that sidewalk safe. If they needed some kind of ramp between the sidewalk
Let me
and
change it up. There, in fact, is a store there, and it's being used by people to go in and out of the store. Does that change your analysis, or you would say that it's still not a ramp and it's still a defective condition on the sidewalk?
It is absolutely not a pedestrian ramp for sidewalk law purposes. It is not exempt from the transfer of liability under the sidewalk law. The adjacent landowner is liable for that lump of cement. Now, whether it is, they had an obligation to keep the sidewalk safe, whether they needed a ramp there or not. There's no evidence they did, and you can see it there. It's the exact same color as everything else. However important it was for them, they had a legal duty to keep that safe to the hundreds of people walking up and down the theater district on any given weekday.
Okay.
Thank you.
Thank you. Thank you both. The next case for argument is John Doe versus Archdiocese of New York. Good afternoon.
Good afternoon, Your Honors. May it please the Court, I'm Concepcion Montoya, and I'm counsel for the defendant appellant, the province of St. Mary of the Capuchin Order. This is a simple case, and it's because the plaintiff improperly invoked the wrong statute in bringing his claim forward.
Do you have to invoke a statute in your complaint saying, hey, my claim is timely? Do you have to do that as an initial matter, or do you wait until someone challenges whether the claim is timely?
I believe, Your Honor, the pleading requirements will give you the option whether or not to plead it. But once you have pled what's in your complaint, the court must be bound to the allegations in the complaint.
So you're stuck with typos. What if there was a typo and they had one digit incorrect? Then they're dead. Is that what you're saying?
No, Your Honor, because this is not a case of a typo. This is a situation where the plaintiff herein specifically said, we're bringing forward 208B, and here's the reason why. I am 53 years old. 208B says I have until I'm 55 years old. So therefore, my claims are timely. Never did they invoke the other provisions of the Child's Victims Act.
Why can't they invoke it in response to your motion? What's the prejudice? I simply don't understand.
Well, Your Honor, they could have amended their complaint in
No,
response.
that's not my question. My question to you is why not in opposition to your motion to dismiss, oh, okay, you got me, got the wrong statute, this is the right statute, court, consider it.
They never asked the court to do that. In fact, in their opposition, they continued to insist that the 208B was timely and it was told by the executive orders of the governor. This is, I'm referencing their opposition to the motions to dismiss. In fact, on their appeal, for the very first time, they said, we made a mistake. We mistakenly referenced 208B. That is on their opposition to this appeal, but it doesn't matter. Well, it does matter, because you specifically gave us notice that your claim is timely because he was so...
Legally prejudiced by their mistake?
I'm sorry, Your Honor?
How are you legally prejudiced by their admitted mistake?
In the matter of the statute of limitations, prejudice is not required. The burden of a plaintiff is to show either that there is a tolling for the applicable statute or the statute was not applicable at all. They never argued that. Instead, they continued to insist that 208B is the correct vehicle upon which to bring their claim forward because of the age of the plaintiff in this case.
So again, how are you prejudiced by their mistake?
The prejudice in the mistake, Your Honor, is simply because this claim has been...
So the claim continues, but that's not legal prejudice. A case continuing is not legal prejudice. There must be something that prejudices you, right?
That's correct, Your Honor.
And what's your prejudice?
The prejudice in this case is simply that we are going to be altering what was pled in the complaint. We have every right to rely on what was pled in the complaint. We based our defense and our motion to dismiss.
I mean, this is just a motion to dismiss. You didn't get to a defense yet.
I'm sorry, Your Honor.
This is just a motion to dismiss. You didn't put in an answer yet, right?
That's correct, Your Honor.
So what you're talking about, you're basing your defense. I mean, you didn't even get through the complaint and the motion to dismiss. So I don't understand how you're prejudiced. The facts are all there. It was just the wrong statute.
Your Honor, at the end of the day, the CVA are cases that have gone on, bring claims for 40, 50 years ago.
We
This is a
understand
case
that,
of
but
40 years
that's
ago.
what that statute permits.
Through 14G permits that.
Correct.
And there are many other portions of the Child Victims Act, not just involving 214G. 208B indeed is one of that portion. The revival portion of the statute is only limited to 214G, which again was not invoked here.
Again,
In fact,
I don't see how, I have to sort of piggyback on what Justice Singh said. I don't see where there's any prejudice. All you've done is made a motion to dismiss, they've clarified it, then you move on with your case. It's still 30 or 40 or 50 years later.
If I may, Your Honor, they never clarified they made a mistake, really. It was the judge who did say they made a mistake. They would not have a claim at all under 208B because that applies prospectively. They did not plead that.
Okay.
But here we are with 214G, and our position is that the court went outside the pleadings, and it shouldn't have.
Okay.
Thank you.
Thank you. Counsel?
Good afternoon, Your Honors. May it please the court. I'm Catherine Anderson, and I represent the respondent, Plaintiff John Doe. Overturning the trial court's order and throwing out this case would be an extreme measure. At best, appellants point to a technical issue in our pleading, which we admit is a mistake.
It was a mistake you compounded, quite frankly.
I'm sorry?
It's a mistake you compounded through motion practice.
We did argue both that either Section 208 or Section 214 could be applied and that tolling would continue to extend 214 until many days after we filed. It turned out the lower court looked at our analysis and said 214 does apply, but it's only a 90-day window, and you made it. You filed it the right time.
Made it by a day, I think.
I'm sorry?
Made it by a day.
We made it
the last day, I think.
And that's
you filed on the last
what's important, Your Honor. We're not required to plead the statute of limitations. The statute of limitations is an affirmative defense. We fully raised.
How do you respond to your adversary's argument that the court went essentially outside the pleadings to reach the determination?
The court did not go outside of the pleadings. The pleadings are very clear that this is a child sex abuse claim that occurred in the late 1970s and the early 1980s, and that our client is a 50-plus-year-old man. Is my time up?
No, you, until it turns red, if you have anything else you'd
Okay,
like to.
my
anything else.
apologies.
That's okay.
So I don't have anything else unless the court has additional questions. We believe the lower court got it right, and that the lower court's order should be affirmed.
Thank you.
If I may, Your Honor, just very briefly.
Sure.
My adversary says that they were not required at all to plead the statute of limitations. However, they did plead it. They did write, and they explained why they were moving under 208B. And our position is that, especially in this situation involving the Child Victims Act, which there's so many cases flooding the courts, that if a court is allowed to simply correct the mistake of a litigant, especially when it reaches concerning the statute of limitations, our position is
But if there's no obligation to plead the statute of limitations, it's an affirmative defense, you haven't yet explained to this panel what the prejudice is. I don't see why we should play a game of gotcha as opposed to allowing the case forward under the correct provision.
Your Honor, we are not proposing a game of gotcha. We are simply proposing that here are the rules that we follow. A litigant is held to the four corners of the pleading. A litigant is held to what they pled. That is what we look at. That is how we base our defenses. That is how we craft our strategy. And frankly, here, especially with the statute of limitations, where the legislators have said it cannot be altered under CPLR 201, our position is simply the plaintiff must be held to what they have pled.
Well, I mean, other than the wrong statute, the facts, whatever facts are pled, those aren't changed, correct? So you know what the case is about, you know what their allegations are, it's just that it's a different statute. That's what, a different statute of limitations. How really does that affect anything that you're going to do going forward?
Well, that is true, Your Honor.
And I'm sorry, and there's no dispute with respect to the application of an executive order at the time to toll, regardless of any statute of limitations, correct?
Well, the executive orders did apply tolling, yes, that's correct.
Okay, thank you. Thank you both. People versus Cruz?
Good afternoon, Your Honors. May it please the Court. Sarah Chaudhry for Appellant Carlos Cruz. In exchange for his guilty plea for a low-level drug offense, the court promised to place Mr. Cruz in a judicial diversion program. However, on two separate occasions, the court failed to uphold its bargain by placing Mr. Cruz in two programs that were inappropriate. Before I get into the appropriateness of the court's placement, I'd like to talk a bit about the backdrop of this case. While attempting to buck a lifelong drug addiction born out of significant trauma, Mr. Cruz was also grappling with his wife's postpartum depression, as well as the birth of his child 3 months prior to his plea, and his child was born with significant medical difficulties that necessitated neurosurgeries and heart surgeries. So when the court first placed Mr. Cruz in the Odyssey program, it placed him in an inpatient program, which was the appropriate placement in terms of it being an inpatient program. Inpatient programs are the types of programs that are most equipped to deal with individuals suffering from not just significant drug addiction, but the sort of personal turmoil Mr. Cruz was also embroiled in at the significant time. The Odyssey House, though, itself stated that it was unable to meet Mr. Cruz's medical needs, which were serious grand mal seizures, which Mr. Cruz has suffered from since he was a teenager and was a consequence of a violent robbery that occurred when he was a teenager. Now, at this juncture, the court then placed Mr. Cruz in the New Directions program. The New Directions program, however, was an outpatient program. The court itself, by its own terms, by its own words, said that the New Directions program was better than nothing. Now, I respectfully submit to this court that that is not the standard. Implicit in a court's promise.
Whose burden was it to present the court with other possible programs that might have, according to you, more fit fit what he needed? Was that something you would bring to the court's attention?
No, I mean, that's a great question. I think that I would submit that it was the court's responsibility in order for it to actually uphold its end of this bargain. The plea agreement, as we all know, is really, it sounds in contract. So the court was saying, in exchange for your guilty plea, I'm going to place you in a program. Now, if that program is ill-equipped to deal with Mr. Cruz's significant issues, it's kind of a nullity. There's no point in doing it. It makes a mockery of the statute, however well-intentioned the attempt may be. And I think the court itself signaled that it understood that it was supposed to place Mr. Cruz in, like I noted, an inpatient program, such as the Odyssey House. The court itself acknowledged, and I assume the court was well-intentioned, but again, that's not the standard. The court itself acknowledged that the New Directions program was better than nothing, again, not the standard, and the court committed a distinct and discrete error then at sentencing. So first, it fails to place him in the appropriate programs, but then when the prosecution, defense counsel, and the court itself are willing to take a look at Mr. Cruz and say, this man is suffering from all of these significant issues that would unravel any life, let alone a life that is one characterized by this kind of drug addiction, and we've only really given him, when you think about it, less than 2 months of treatment time. Everyone is in agreement Mr. Cruz can have another chance, and the court simply just asks New Directions, does not put on the record why New Directions was unable to take Mr. Cruz back, but denies the request that Mr. Cruz be placed in another program. Now, pursuant to the judicial diversion statute, the court had an obligation to not only take into consideration the relevant circumstances, including the viewpoints of the prosecution, the defense, as well as clinicians, but also to take an appropriate and graduated response to any perceived program infractions. Someone who was suffering from what Mr. Cruz was suffering from deserved better, deserved more than one, an inappropriate placement where the program itself kicked him out, and then an outpatient program that simply was not set up to allow him to succeed. Now, the consequence of all of this was that Mr. Cruz obviously was incarcerated, sent upstate. In the meantime, his child died of the severe and significant illnesses that he was experiencing at the time. And so we respectfully submit that because of these failures and because the sentence has already been served, that this court make Mr. Cruz whole by granting him the ability to have the misdemeanor that he would have received had he completed the programs that were presented to him.
Okay. Thank you. Let's hear from your adversary, and then you'll have a couple of minutes in rebuttal. Thank you, counsel.
Good afternoon. May it please the court. Jonathan Sklar for the people. The people extend their condolences to Mr. Cruz's child, first and foremost. Your Honors, the court gave defendant an extraordinary opportunity to avoid incarceration altogether and pursue...
So your adversary's point, which is well taken, is what's the point of putting this individual in a program where he can't succeed?
Sure, Your Honor. The record in no way sets forth that he was placed in a program in which he could not
Odyssey
succeed.
House, he couldn't be there because of his seizures, correct?
That's not borne out by the record, Your Honor. Your Honor's defendant missed all of his group sessions. The record's a little convoluted, but from what we surmise, defendant was at Odyssey House in the month of June 2018, and he missed all of his group sessions. So for these programs to work, you have to attend the individual sessions and the group sessions. So there's absolutely no basis to determine that Odyssey House was not suitable for him when he's not even showing up to the sessions.
Could Odyssey House, which is a residential treatment program, treat his seizures?
The record's unclear, Your Honor. We don't have sufficient evidence either way whether whether it can treat his seizures or not, or that his seizures were even a problem. Your Honors, he has been absconding from these programs throughout the entirety of the case prior to the plea.
I'm sorry, counsel. I thought the court said that on the record, that they couldn't treat him because of his medical issues.
The court does, the judge does state in one sentence that there were some issues that Odyssey House thought they had with treating him, but the people would set forth that because he didn't attend the sessions, Odyssey House was not capable of determining that even. Not to mention that when he went to the outpatient program.
Based on that, was there an objection by the people to outpatient treatment? wouldn't the people's natural response be that he's not compliant with the Odyssey House program, he's violated the terms, and that's the end of it?
No, Your Honors, the people wanted to extend and did extend Mr. Cruz every opportunity to succeed. We want defendants with these kinds of issues to succeed. I'll note that this was not a minor infraction or a low-level drug offense. He's a drug dealer. The guy's a drug dealer. He's been convicted of drug dealing offenses. He was convicted of attempted drug dealing here. It's a Class C felony. And also, as to his son, right, his son, we're very sorry for his son's loss and his medical issues, but the hospital actually sent the court a letter stating that while his son is in the hospital, his mother is by his side. And the clear implication being that defendant was not by his side. So defendant is, and this was the court's, the court below's view was that he was using his son's medical issues as an excuse to avoid treatment. But the record is clear that he absconded from treatment multiple times, including a warrant had to be issued just for him to return to court. He did not take his rehabilitation seriously.
So that does not seem like a person that would necessarily benefit or succeed in an outpatient program. So it seems that by the court suggesting he goes to an outpatient program, it was sort of bound to not succeed. So to the extent you're saying we would like to see him succeed, that does not seem like a good program for this individual.
Your Honors, I'm not sure how you determine what is a suitable program. However, I'll note that the statute affords the court broad discretion to determine what programs, and here it simply did not abuse its discretion. Also note quickly that this issue was not preserved. They did not, defense did not object on the record below, so it's unpreserved. It's barred by his appellate waiver. So if he gets over...
Post-plea conduct is barred by the appellate waiver? How could that be possible? How can you bar something or waive something that you don't even know yet?
So Your Honor, admittedly, the first department, to my research, has not ruled on this issue. The third department has held that if the appellate waiver does apply, and the people would submit that this is not the kind of constitutional issue that goes at the heart of due process, like ineffective assistance or an illegal sentence where that would survive an appellate waiver. So this is very much the type of issue that would be foreclosed by the appellate waiver, as it is here. And defendant, who has been convicted 15 times, is well aware of how appellate waivers work, and he cannot claim to not understand it. Thank you for your time, Your Honor.
Sure, thank you. You have 2 minutes on rebuttal.
Thank you. As an initial and overarching matter, respectfully, my opponent mischaracterizes the record time and time again. The court's very own words when discussing the Odyssey House program and Mr. Cruz's inability to so-called finish it was, I want to be very clear on this. When the court attempted to place Mr. Cruz at Odyssey House, which is a residential program, they felt that they were unable to because of his claim that his medical issues were properly treated. It's a bit unclear while the court tries to be clear, but I think we understand the import of that, which is Odyssey House was unable to...
Can you address your adversary's point on the waiver, that it applies to post-waiver conduct?
I would take your Honor's assessment on that. I certainly just don't understand how, when you're in a position and you're waiving your right to appeal, when we look at the issues, it's usually the sentence, which you're well aware of, any sort of suppression decisions, which you're well aware of. Anything that happens post-plea, I think, puts us in the juncture of a lot of the post-plea cases, which is you certainly, absent any sort of and I know this is not an outly situation, but absent any sort of a hearing, you were simply not just able to waive your ability to appeal claims that were inchoate, that didn't even exist as of yet. So I personally don't believe that the appeal waiver, though I think it also suffers
And is
from...
there case law that supports your position?
Well, I would say that there isn't much case law in this particular area, but the case law that we have, including the Court of Appeals cases, doesn't quite address this situation. I think it's most analogous to the post-plea cases, which you've alluded to. So the waiver itself has certain infirmities, but I would submit that given that this is post-plea behavior, that Mr. Cruz couldn't voluntarily and knowingly waive claims that just did not exist yet. Now, to counsel's other point, which was essentially that my client is an incorrigible offender, I'm not sure, I don't want to spend too much time on this, but clearly the judicial diversion statute understands that that kind of reasoning is actually what it's, may I continue?
Yes.
That kind of reasoning, that kind of moral judgment is what has brought us into this situation where we needed to have a judicial diversion statute because we understand that people like Mr. Cruz, who are low-level offenders, are apt to and are likely to have multiple drug offenses on their record precisely because they are supporting their own habit, which is a medical issue. So I would respectfully ask this court to follow the reasoning of Jimenez and Feliciano and make an assertion and assessment that when you were promised judicial diversion by the court, you are promised a meaningful opportunity to have treatment. And I thank you for your time.
Thank you. Thank you both very much. Grasiano versus Landmark.
May it please the court.
Just, okay.
My name is Jean-Pierre Van Len, Cullen and Dykeman, counsel for Appellants, Landmark Group, and Federal Insurance Company. This is an appeal from a trial decision, a bench trial.
So you would agree that, based on the earlier order that this court addressed, that Judge Cohn, after trial, was in a position to determine factually whether the Addendum 3 was in fact a cardinal change under the contract?
No, Your Honor. That issue had been foreclosed on summary judgment and affirmance by this court.
We said, in this regard, the court correctly found that issues of fact exist as to whether Landmark's issuance of Addendum Number 3 breached a fundamental obligation of the contract, relieving whatever. So that's what we found in 2020.
That, Your Honor, that was in context of Landmark's counterclaim alleging delay, and the breach of a fundamental affirmative obligation of the contract is one of the 4 exceptions to the no damage for delay clause. And the breach of a fundamental affirmative obligation of the contract as an exception to the no damage for delay clause does not vitiate the contract. It may vitiate the exculpatory aspects of the no damage for delay clause, but not vitiate the contract. A cardinal change per se rescinds the contract, invalidates it.
And it's true that the court at that time did not use the term cardinal change. They did not deal with that concept.
That's correct, Your Honor. We contend that the proper framing of the issue by the trial court was not whether there was a cardinal change, but whether there was a material breach. Now, the difference being that a material breach doesn't arguably rescind the contract or rescind any contractual defenses, whereas a material breach preserves contractual defenses. In this case, the court, based on its cardinal change finding,
right,
and its misreading of this court's decision that a breach of the contract would absolve Grasiano, the subcontractor, of the effects of the no damage for delay clause, doesn't vitiate the contract. There's a conflation here between breaching a fundamental affirmative obligation of the contract and cardinal change. The Court of Appeals in Corino-Saveto, which is the genesis of the 4 legal exceptions to an otherwise ironclad no damage for delay clause, characterized the breach of a fundamental affirmative obligation of a contract in a very narrow way as being a denial of access, such as not giving permits or obtaining and requiring a contractor to pursue construction work and the like. It's not a rescission of the contract.
Well, here, Justice Cohen was essentially saying that using Section 8.1 to authorize Addendum 3 in the way that you propose would essentially nullify Article 13, because Article 13.1 only allows, you have to have for cause under Article 13.1.
Well, Your Honor, there are two sections. There's a for cause and a termination for convenience. And as I understood the court's decision below, it was saying, he was saying that
I did turn that into sort of a hash. I'm sorry, I wasn't very clear about the sections. Essentially, it was saying you were nullifying the contract through change order, where you're not allowed to do that.
Your Honor, if you look, Article 8.1a relates to a deletion, modification, or alteration of the scope of work without invalidating or abandoning the contract. Scope of work, Article 2.1, contains a section which allows, based on non-performance and failure to keep the progress schedule,
But see, which is fine. but
takeover of work.
The problem I'm having with your argument is the court below found absolutely contrary to what you're saying, is it was your client that caused the breach in terms of all the scheduling delays, et cetera. So would you address that? Would you agree with that characterization of the court's decision? That your client was in breach of?
No, I do not. I do not. Your Honor. There was they exercised their rights, legal rights, under 8.1a for non-performance. There was no question that they were asserting there was non-performance. And Article 2.1a allows them to do so. The court did not look at Article 2.1a and that portion of it, which allows the takeover of work that has been
But the thing is, the court did listen to this testimony. I know there was a big record, and Judge Cohn wrote a long decision, but he found, that Grasiano gave you notice that there were delays in their ability to start the work, and I read something that you sent to, who's the owner of the project, that you said, look, there have been delays, but it's really not Grasiano's fault. It has to do with weather. It has to do with the steel contractor. It has to do with all these other people not doing their work. It was not sequenced right. They just couldn't possibly start their work till other things were done first. You really didn't blame them. It did not appear to be their fault. And then you took a lot of the work that they were supposed to do and either did it yourself or gave it to someone else, sort of, getting rid of the whole purpose of the contract. That, the judge found, was a cardinal change.
Well, first of all, cardinal change is not the issue here, we contend, based on law of the case. Material breach.
Well, let's assume we disagree with that.
But addressing, Your Honor, the SC, if I may complete.
Yes, please.
The SCA, in 4 delayed letters, noted that there was a failure on Grasiano's part.
You're retrying the case before us now, and you've already lost that below. That's what you're doing.
I don't think so, Your Honor, because I think the cardinal, I don't believe that's the case, Your Honor, because there was, let me just, if I may.
Finish this answer. Go ahead.
There are contractual defenses here, which the court basically ignored, overlooked, just summarily dismissed. And one of them is extra work. And for purposes of extra work in the contract, it is a strict essential precedent.
But the court didn't determine below that change order they sought for the extra men they had to hire was not because of work needed, but because of delay. And if because of delay, the condition precedent that you were referring to in 3.4 or whatever of the contract are not implicated.
I was speaking to, may I speak to that, Your Honor? The no damage for delay clause, however, does address the acceleration. Acceleration costs are delay. And Grasiano's claims did not fall within the exceptions to the no damage for delay clause. At most, the court's finding of a lack of coordination by the GC and failure to properly schedule a project by this court's very own decisions not amount to more than inept administration and poor planning, which do not constitute a gross negligence or willful misconduct exception to the no damage to delay clause, and do not constitute a fundamental breach of an affirmative obligation of the contract. Grasiano failed to put any proof in that it had complied with the extra work, strict notice requirements, which, if not observed, waive the claim. None. And they failed to prove an exception to the no damage delay clause for the accelerated manpower work.
Okay, let's
Lana's addressed.
let's hear from Grasiano. You'll have a few minutes on rebuttal. Thank you very much.
Thank you, Your Honors. May it please the court, George Marco for the respondents, Grasiano and Liberty Mutual. I guess I'll start with the law of the case argument, which I don't feel was ever preserved for appeal. Throughout trial, before trial, Landmark was always in agreement with the court that the main issue to be tried in this case was whether or not Addendum 3 was a cardinal change to the contract.
Well, we use the word fundamental obligation. Is there a distinction between that and cardinal change?
Quite frankly, Your Honor, the prior decision, it's a little bit fuzzy. But there is nothing in the prior decision or the decretal paragraph which says anything other than they affirm Justice Branston's summary judgment decision. There's nothing for...
Your adversary contends that that relates to this issue where we discuss that relates to their counterclaim. Do you believe that's correct?
No, it does not. Justice Branston originally dismissed Grasiano's quantum merit cause of action because at the time that Grasiano filed its complaint, there was a contract. There was the existence of a viable contract. That's why.
Well, that was a separate.
It wasn't dismissed because of the issue of a cardinal change was determined by somebody. That was left actually for trial, and she specifically says that in her original summary judgment order. She says that the issue of whether Addendum 3 constituted or breached or constituted a cardinal change to the contract is an issue of fact for trial, which is what we spent 8 days trying. That's what they argued in their pretrial brief. That's what we argued at trial, and that's what they argued in their post-trial brief.
How do you respond to the argument that essentially Article 8.1a, I think, permits Landmark to delete the scope of the work?
It does. It permits changes, ordinary changes, typical changes in construction, do changes in plans. It does not allow somebody to defeat the main purpose of somebody's contract, which is exactly what they did.
This is essentially a reassignment of the most lucrative portions of the contract.
Exactly.
A reassignment to itself.
Exactly. And there's no clause in the contract that lets them do that. I know they have a new novel theory now under Article 2.1, which again was never raised at trial. Under this new theory, they combine 2.1 with Article 8.1, and they say, well, see, because of this language, when you put it all together, we had the right to strip Grasiano of its work. Article 2.1, at best, gave them the right, based on Grasiano's non-performance, to have them assign purchase orders for vendors. Okay? That's all it did. The only provision in the contract which allowed Landmark to effectively delete work and self-perform it is Article 13.1. And that's the either termination for cause or termination for convenience.
Wasn't there...
They did not invoke either.
I'm sorry, counsel. Wasn't there testimony by George Manasalakis, who was a key person for Landmark, that made it very clear that your client was not in default in any way?
Oh, yeah, absolutely.
So the so-called of non-performance really had nothing to do with your client, but it had to do that Landmark didn't properly schedule and scope everything the right way.
Exactly. He testified, I'm sure, at deposition to that fact. Yes. I'm not sure if he admitted it at trial, but at the deposition, he said, yeah, no, they weren't in default. Then he tried to say that, at one point at trial, I think he said that, Well, we were trying to do Grasiano a favor. We didn't want to hold them in default, so instead we just took their work away, basically, and left them with some other work. Look, the bottom line is that the only credible reason that Landmark gave at trial for deleting the work was that it didn't want to pay acceleration costs. That was the only credible reason they had. They had, other than that, it's clear that, number one, they breached the contract initially by failing to provide a scaffold, failing to provide access, failing to even provide a project schedule. Then they had this ridiculous contract with their steel contractor where the steel contractor only had to supply a certain number of people, and they basically told Landmark, we're not supplying anymore. So what did Landmark do? They were forced to actually delete that work from their steel contractor and do it themselves. All of that work was predecessor work to Grasiano, so they couldn't do anything. Instead of working with Grasiano, what did they do? They turned around, they forced them to accelerate, they blamed them for delays, and then when they couldn't agree on an acceleration change order, because Landmark had offered a certain sum of money, they deleted the work.
It was like $400,000 for a $1 million claim, ultimately.
It was 190 they offered, but they demanded that Grasiano release any future claims and that they finish the job at an unrealistic date. In fact, Landmark finished the job in October of 2015. They were demanding that Grasiano finish it in January of 2015. Unless you have any further questions, I'll rest on my brief, Your Honors, and ask that you affirm Judge Cohen's decision.
Thank you.
Thank you.
As for the negotiations between Landmark and Grasiano and the $190,000, specifically, Landmark told them, you're not entitled to this according to the no damage for delay clause, but we want to progress the work. They did not insist that Grasiano waive all future delay claims. What they said was, in connection with the SCA standard practices, which there are negotiations that only occur after completion of the project, we will put in your delay claims. If you get paid, if we get paid on those, we'll get reimbursed for the 190 and you get everything else above. As to Judge Branson's decision, she said that there's no, that the allegation or statement that Landmark intentionally abandoned the contract in issuing addendum 3 is unavailing. You cannot have a quantum merit cause of action based on cardinal change and rescission of the contract and at the same time seek contract relief. They are mutually, and it's an election of remedies situation. You can't go to trial with both for the same damages. Cardinal change should not have been addressed here. And whether or not an alleged breach goes to the essential identity or of the contract is also a consideration in material breach. The difference being it doesn't vitiate the contract or contract offenses, such as here. And there were delays by Grasiano.
But see, I think that's where I'm having a disconnect because essentially the court made credibility determinations based on the testimony of the very well pronounced name here by my colleague of the Greek gentleman. But it found that Landmark caused the delay, that Grasiano was not in default, and that addendum 3 was not a deletion, but rather a reassignment of the work from Grasiano to you. Those are the findings of the court that we need to address.
In that regard, just assuming, I don't believe the court was correct in that regard, and I think the record...
But there were credibility determinations. I know we can make our own credibility determinations here, but those were the court's credibility determinations based on your client's admission.
I respectfully submit that findings of fact as to whether there were delay and who caused it are not credibility determinations, those are findings of fact. But let me say this. One of the aspects of the no damage for delay clause is not only do you have to show that the delay that was caused falls within one of the exceptions, but you also have to show the absence of other concurrent delays that would fall within the exculpatory provision. And the court did not do that here. The court mentioned multiple causes of delay. Causes of delay on different site conditions, requests for information that took an inordinate amount of time, and so forth. And the winter, it didn't mention the fact that the scaffolding in this case was delayed by extreme winter weather conditions. None of those cited causes that the court acknowledged are fault of landmark. And if those causes are concurrent with the delays for which the court held landmark responsible, there's no recovery.
Okay. We have your briefs. We'll take another look. Thank you both for the arguments this afternoon. Next case, Prismatic Development.
Good afternoon, Your Honors.
Good afternoon.
I'm Howard Rosen from Picard and Abramson for Appellant Prismatic. From the outset, I wish to stress that Prismatic is appealing from a pre-answer dismissal. This is not from summary judgment. There was no answer to the complaint, and there was no discovery. The factual record here is very limited. We believe that that situation led the trial court to render critical factual errors, which we're appealing here.
But isn't it all whatever the performance bond says, counsel? In other words, so that you rise or fall on the provisions. And in this case, of course, it's the conditions precedent that the court found to be dispositive.
Well, our position is that those conditions precedent could not be satisfied under the facts in this case. They were not, they were waived, or they just were not feasible. That in effect,
because is it your argument because of preconditions? It's with respect to the post-indemnification obligations. Is that the reason why you're saying that the condition precedents don't apply?
we're saying they don't apply because Judge Cohen rendered a decision saying, based on his findings, that Prismatic failed to give notice, satisfy those conditions, while Nasarima was performing work and knew that Nasarima's work was deficient. And that's not the case. There's no evidence in the record to support that finding. And that was the basis for his decision. He also rendered part of his decision was that Prismatic did not give notice to the surety. When I can go back to the facts a little bit, if you recall what happened here.
Well, I mean, the thing is, our courts have required strict compliance with the preconditions and the conditions precedent that is set forth in that standard form. They've been very, very careful and strict about doing that. So I think the judge pointed that out. And how do you get around that?
Well, the performance bond incorporates the entirety of the subcontract, including the defense and indemnity provisions. It binds both Nasarima and the surety to that contract. It's incorporated by reference. If those conditions that relate to performance cannot be satisfied or not applicable, then in effect, there's no basis for finding that there was a failure to comply with those in a situation where it was not possible, and that subsequently there was a claim produced or generated by EIC saying my work was interfered with by Nasarima's poor performance. But there was no opportunity for Prismatic to issue a notice of default, to call in the surety, because they had no knowledge of that while Nasarima was performing the work. And there's nothing in the record to suggest they had that knowledge. What needed to happen...
Once EIC pointed out the problems with the debris and stuff like that, you know, why, I think that your client then said to EIC, you fix it. And they wanted an opportunity to fix it themselves.
Okay, so this goes to, you have to have a visualization of what's happening here. This is the construction of...
It's underwater. It's literally underwater. We know that.
Right, and
But
EIC
EIC
is working...
still identified the problem. And at that point, you know, didn't, you know, shouldn't they have allowed the other side to come in and ameliorate the problem?
It was not completely infeasible, impossible for that to happen. What's happening is EIC is working off barges. They've got cranes. They're trying to dredge the river and drive piles. There's no way for anyone, Nasarima or the sureties, completion contractor, to come in and remedy anything. The debris, the obstacles are under the mud. So the only feasible way of dealing with the situation was for EIC to continue its dredging operations and its pile driving, and some of this debris is their responsibility. So it's going to be a mix of responsibilities, and then put together their paperwork and submit proofs of claim so that Nasarima can then be held responsible to the extent of its liability there.
One of the conditions preceding is 3.1, which posits that there should be discussions about what to do if there's this kind of problem. And that didn't happen.
It would have served no purpose to have discussions of something that's ongoing at the time. There's nothing to discuss. EIC had control of the site and was performing that work. What was there to discuss at that point? Nothing. The discussions had to...
Wouldn't IFIC be entitled to an opportunity, at least, to engage in a remedy? I mean, isn't that the whole point of the discussions, to see what the issues are? And in fact, what happened here is that you declared Nasarima in default well after the problems as perceived were remedied.
Prismatic declared Nasarima in default of the defense and indemnity agreement, not the performance of the work. When EIC...
What, they're not tied together? Aren't they essentially, that's sort of the end result of why indemnification is sought, because there is deficient work?
Well, it's tendered to them to show that they were not in default, that they did their work properly. That's why Prismatic's subcontract requires Nasarima to defend and indemnify Prismatic against any claims that arise from their work. And that's what was done here. And there's a third-party action now against Nasarima, looking for that defense and indemnification.
Okay, well, this may be a good opportunity to let's hear from your adversary, and you'll have a few minutes on rebuttal. Thank you.
Thank you.
Counsel.
Good afternoon, Your Honors. Adam Friedman for the respondent. Every decision from a state or federal court in the state of New York, going back at least 20 years, has held that an obligee's failure to strictly comply with the conditions precedent in this form of performance bond precludes a claim.
The argument here is that it's impossible, because we're talking about post-indemnification obligations. How could there be discussions?
There are a number of answers to that question, Your Honor. The first is they say it's impossible, but they don't cite the law about impossibility and what constitutes impossibility. Impossibility is an act of God or an act of law. It was not impossible for them to satisfy paragraph 3.1, which was give us notice that there's a problem and have a meeting so we can sit with them and we can sit with Nasarima and we can discuss a resolution. They never did that.
But wasn't it true that they didn't know the problem till well after Nasarima had finished their work and had already been paid?
Let's assume that's true, Your Honor. What stops them from giving us notice that there is a problem and
as soon as they know about it?
As soon as whenever they know about it. Give us notice, Let us, in the surety world, in addition, when a surety bonds a principal, we take an indemnity agreement from the principal and then the individuals associated with the principal. The point is that we have certain leverage over the principal that we can attempt to enforce, to resolve a claim before it becomes a claim. But we can't resolve a claim before it becomes a claim when the obligee doesn't give us notice. Let's assume that 3.2, the default, was impossible. I don't concede that it wasn't, but okay. Paragraph 3.3 says all they have to do is agree to pay us the contract balance that remains, whatever it is.
That's one that seems to be really impossible to do because there was no contract balance. You paid everything to Nasarima at that point.
So I have two answers for that, Your Honor. The first is all the law requires is that they say they agree to pay us the contract balance. It can be zero, it can be a sum of money, it doesn't matter. They have to agree to pay us the contract balance because there may not be an agreement between the surety and Nasarima on one hand and them on the other hand. The other issue is that there is a contract balance. They, Prismatic, on behalf of Nasarima, submitted a claim to the Department of Sanitation for costs that Nasarima claimed it incurred, which ultimately were the responsible of the Department of Sanitation. Prismatic, on behalf of Nasarima, recovered money from the Department of Sanitation on account of some of those claims. Counsel is still holding that money in escrow. That is money that would be due to Nasarima under the subcontract. So they should have, even, let's say, the law is not, if it's zero, they're absolved, but let's say if it was zero, may I complete?
Please.
If it was zero, they would be absolved. The contract balance is not zero. There's 6 figures in their escrow account, so they were obligated to comply with paragraph 3.3. There's no mention of that in anyone's papers anywhere. So thank you very much. We ask that you affirm the lower court.
Thank you.
In the motion below and in the appeal, in the briefs, we've challenged counsel for IFIC to explain how, under the circumstances, under the facts of this case, there would have been a discussion, a meaningful discussion, at the time when EIC is out there performing its work and saying, we've encountered obstacles, we think that Nasarima, many months ago, left debris in the river. There's no explanation of what could have been done by Nasarima or the surety. It's
Well, but wouldn't the response be is there's no explanation because you didn't give them an opportunity to have the meet and discuss to see if there are any, if there's anything that can be done?
Fine, if counsel could give a scenario as to what that discussion, how not having that discussion deprived them of something that they actually could have acted upon. And what we're saying is under the facts of this case, the facts of this case are far different from all the cases cited by Mr. Friedman. I've looked through every case they cited, and in each case, it was feasible for the claimant under the bond to have acted and given the surety notice, and instead they neglected to do that. They went ahead and did whatever work they were going to do, and then sued under the indemnity. We're saying under the facts of this case, that could not happen. Sure, it's very easy to come up and say, well, you should have sat down with us and told you what, to do what. And by the way, the bond doesn't require notice to the surety of a defense and indemnity claim. It only requires notice when there's going to be a demand to complete the work.
Well, I mean, Judge Cohen did recognize in the very first paragraph of his decision that the timing and the facts of this case were pretty unusual. You know, he said in a typical case, these are the facts. Here, you know, Nasarima finished the case. So we are aware of the fact that it comes in a different place than it usually does. And do you want to just finish up because
yeah, I'm going to finish up right. I think discovery is needed to establish, for the record, Prismatic's lack of knowledge and opportunity to invoke the bond during Nasarima's performance, and also to show the lack of a feasible opportunity for the surety to perform even if they had sat down and talked to the surety. The outcome contemplated by IFIC is that this indemnity, defense and indemnity clause is being written out of the performance bond. That's their position. It doesn't exist here under a circumstance where the work has been completed. And I don't think that's the law, and I don't think there are cases supporting that.
Okay, thank you. Thank you both very much. Next case for argument is Lynch versus Board of Education. Good afternoon.
Good afternoon, Your Honors. If it may please the court, Jimmy Wagner for the appellant, Tina Lynch. The first issue I would like to discuss in this special proceeding was the lower court's denial of the request for discovery. So the Court of Appeals and this court have routinely held discovery in special proceedings is only permitted when there is ample need and unusual circumstances. I would beg to this court that the ample need here is this was a 30-year tenured teacher who no longer gets to work. The ample need is her salary, her job, her livelihood. But even if the court was not to consider that ample enough need, I would say let's look to the unusual circumstances. COVID created an entire environment that created new case law. Prior to COVID, a tenured teacher could never be removed from a term of teaching without a due process hearing. Here, this tenured teacher was removed from a term of teaching, not because she did something wrong, not because there was some allegations of
Also, Mr. Wagner, what I understand you to say is that the sort of the fix was in. You know, you rely on that letter from DOH at Record 370, which is telling people about how the vaccines were developed and the use of fetal cell lines in the manufacture or testing of the vaccine. So that is my understanding, is what your thread is to get more discovery.
That's correct. So
can you unpack that a little bit? Why would this be that?
I will. That what you're looking at was items that I obtained in a separate FOIL lawsuit in Queens. We received those documents from the Department of Mental Health, which showed at the time my client was making her application to the arbitrator. The arbitrator was getting from the respondents the how to deny religious accommodations for Christians. Along with that document you're looking from that went to the arbitrator was that email that's been completely redacted that states UFT emergency accommodation process. So we know unequivocally that prior to my client having her fair due process, the respondents was sending items to the arbitrator.
But then the Second Circuit case happened, of course, and then you had to go to the citywide panel. So why would this letter necessarily lead to more discovery? Because it only pertained to, at most, to what the arbitrator did.
No, Your Honor, in reference to what the arbitrator did. So the Second Circuit case, number one, it was supposed to, it applied to 16 individual plaintiffs. The city then let everyone who was denied initially reapply, but it wasn't a true reapplication. If we look at the affirmation of Eric Eichenholz, and that's in the record 288, what he does is he just looks at collectively what had been previously submitted, and then he applies the wrong legal standard. That's paragraph 13, 288, he applies the de minimis standard. And Judge Moulton, I know you're very familiar, I believe you were the...
I was on the Hogue case, yeah.
Right. So what happens here is they apply the wrong legal standard. And in this record, it's not just once, twice, it's 3 times. On page 59 of the record, they apply the minimal standard. Page 239, respondents' answer to this complaint, they say, we only had to apply the de minimis standard. New York State and New York City have never used a de minimis standard. We have always been a significant burden. So when we take in totality of what happened to this teacher, she applies for an accommodation where we have information that the arbitrator was being told by one side how to rule. She's never given an opportunity to respond. And then the city, its own panel of experts in the citywide panel are using the wrong legal standard. New York City has always been significant burden. There was, when we moved to the amount of teachers.
Mr. Wagner, wouldn't we have to essentially overrule Hogue if we agreed with you on that point?
I would humbly ask this court to look at each individual Article 78 as an individual case. I do believe Hogue should have not been ruled the way it was. I don't believe the court in its history traditionally questions the sincerity. Ms. Tina Lynch's denial was strictly on undue hardship, where Mr. Hogue was also a sincerity and undue hardship issue.
I thought the court, I mean, this doesn't really matter, but in Hogue, I thought that the trial court said he wasn't questioning the sincerity.
Said that. Your Honor, you're correct, but this court's decision in Hogue actually did question the sincerity. And what you said was that because he had used a pre-form piece of paper to help him with his religious accommodation request, we're not, even though that's not going to be the fundamental factor, we are going to say we do believe potentially he doesn't get to sincerity. And I think part of the reason why we're coming to the sincerity issue is because the court feels first you get to show sincerity, and then we're able to address the undue hardship. And what I'm saying here is we know this record in the city's answer at 239, they state unequivocally they applied the wrong undue hardship standard.
Okay, let's hear from the other parties, and we'll hear back from you. Thank you, Mr. Wagner.
Good afternoon, and may it please the court. Rebecca Viscatus for the New York City Department of Education. This court's decision a few weeks ago in Hogue is exactly on point here. And just as in that case, the record demonstrates that DOE and the citywide panel had a rational basis to deny Lynch's accommodation request. This court specifically affirmed in Hogue that DOE's position statement, which explains in detail why granting exemptions from the vaccine requirement would create an undue hardship under the circumstances present at the time, established a rational basis for denying a teacher's request. Exactly the same rationale applies here, and I think this court would have to issue a decision completely in conflict with Hogue in order to rule in the petitioner's favor. In the initial determination here, DOE explained that regardless of whether Lynch had sincerely held religious beliefs that precluded vaccination, granting her an accommodation from the vaccine requirement would present an undue hardship. And the position statement, which the Eichenholz affirmation establishes that the citywide panel specifically considered, lays out in great detail the reasoning behind that decision.
Does the position statement explain why masks and testings wouldn't be sufficient?
It does not discuss that in detail. However, it does refer to the fact that the full body of students and staff would be returning to schools that fall for the first time since the start of the pandemic. So even if those mitigation efforts had been sufficient in the previous year for the small number of students and staff who were attending schools, with the full population of schools back, including many young students who were not yet even eligible to be vaccinated, which included this petitioner's elementary school students, those mitigation efforts, based on the CDC guidance at the time, would no longer be sufficient to protect the health and safety.
Could you just could you just respond to Mr. Wagner's argument about whether or not we're using the wrong standard, the de minimis standard, as opposed to the substantial, significant burden? Yeah.
Sure. This is the same argument that the petitioner pressed in Hogue, and this court implicitly rejected.
I imagine it would have been, but I asked you to address it.
And while there were references to the de minimis standard, the position statement and the extent of the reasoning clearly shows that this was an undue hardship under any standard, and that DOE and the citywide panel were considering all of the factors laid out in the city human rights law. So I think they were ensuring that they were applying both or all of city, state, and federal law. At the time, it was well settled that the federal standard was the de minimis standard, and that was simply what they referred to as shorthand in their explanation. However, I think that the extent of the considerations discussed in the position statement here make it clear that this would present a substantial hardship to DOE and its operations.
Okay.
I'm happy to discuss the discovery motion if the court has questions, but
isn't that why you're here to discuss the discovery motion? Oh, okay. I thought that's what he said. All right.
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. My name is Keith Gross from the Office of Robert T. Riley. We represent the respondent, the United Federation of Teachers, in this matter, and we appear here only on the limited issue of the discovery matter. Please note that notwithstanding the lower court's decision, the UFT does not oppose the relief that the appellant had sought in the Article 78 petition. Discovery against the union was not appropriate in a special proceeding challenging the public employer's administrative determination. The appellant's attempt here at showing that there was, quote, collaboration and cooperation, close quote, between the employer and the UFT to her detriment is not apparent in the two documents that were included with the discovery motion before the lower court. The UFT was not a participant in the first document, a September 21st, 2021 letter from the New York City Department of Health to the arbitrator, nor was the UFT a participant in an email chain from September 22nd, 2021 between New York City agency.
But we know very little about the content of that email chain, of course, because most of it's redacted, right?
That is correct.
Was there any kind of in camera about that?
No.
Please continue.
Moreover, the purpose of this Article 78 proceeding is to determine whether the public employer's denial of a religious accommodation to the appellant was arbitrary and capricious. The employer had the sole discretion to make that determination whether to grant a religious accommodation. Thus, discovery against the UFT was not material nor necessary to make such determination. I would further note in relation to the facts of the case that the UFT had already answered the petition before the appellant filed the discovery motion. It seems that some of the arguments in the appellant's brief relate to a delay of 70 days for the respondents to answer or submit a motion, but that only applies to the Board of Education. That did not apply to the UFT, who had already answered in the case. Therefore, this court should uphold the lower court's decision as it relates to the discovery issue. If no further questions, I'll relinquish the rest of my time.
Well, you've finished the rest of your time.
Thank you.
So thank you. Counsel?
Real quick, Article 78, it's not just about arbitrary and capricious, it's about error in law. I have pointed out 3 different times in this record where the respondents admit error in law. They used the wrong standard. The lower court's decision states, in quotes, page 17, while this policy essentially stifles the right of certain employees to apply for a religious exemption accommodation, DOE profits several reasons for enacting it, none of which are irrational or arbitrary and capricious on their face. I believe this was intentional discrimination, but if it's accidental discrimination, as the lower court is stating, the lower court's acknowledging that certain religions are giving preferential treatment in the DOE's policy, and that's okay. Under New York City human rights law, under the Constitution of New York State, it's not okay. We will never get to the bottom to know who these special few people who got this treatment were. We know it. They admitted in the position statement that certain religions were granted preferential treatment. If I could just indulge this court in one small matter. So Pope Francis recently stated, quoting St. Therese, that it is trust and nothing but trust that must lead us to love. And when I read that quote, it made me think of this courtroom and in God we trust. When I see that quote, I always assumed it was for the public. I always assumed it was for us attorneys. I was wrong. It's for the judges. Judges, in God you can trust. Don't trust any of us attorneys. Trust the record. Look at what's written in the record here. The record says these respondents used the wrong standard of law when deciding and declining my client's accommodation. When respondents openly admit this error of law, it gets overlooked. When New York City has long held the standard of my body, my choice, it is now turned into my body, government's choice. This is an individual religious accommodation, 500 teachers out of 95,000. In an earlier case, Your Honor, Osato, you pointed out the difference between a paralegal and a tenured teacher. You're absolutely correct. 3,000 DOE employees, which included the chefs, security, and everybody else. While the chef and the janitor may not have been able to do the job in a different fashion, this tenured teacher could have. And under Phillips, under Hoskins, which was ruled during the pandemic, there was no reason we couldn't have had an individualized accommodation discussion with this tenured teacher. It's just not fair. It's not equitable to this tenured teacher.
Well, I mean, don't we have to give deference to the Department of Education for having a preference for teaching in person? And then they talked about the collective bargaining agreement, how that prevent them from moving people around, and the various constraints they have to accommodate people. Don't we have to give some deference to that?
When we talk about deference, Your Honor, this court doesn't have to give deference any time to the respondents when it comes to issues of law. The issue of law being the wrong standard in denying the accommodation, if we go back and we look at what this court said in Phillips, the first step in providing a reasonable accommodation is to engage in a good faith interactive process. That never occurred here. In Hoskins versus Sloan Memorial, which was just decided by this court, you reinforced Phillips. You turned around, your quote, defendants' unilateral determinations are unacceptable. That's exactly what the respondents did here. There was unilateral determinations to deny every religious accommodation for everybody, whether they were Jewish, Christian, or Islam. They just denied every religion. Done. They gave the sham illusion of a religious accommodation process. It was non-existent. And if the court would just send me back down for the discovery, we can just look at that unredacted email. Let's see what really transpired. I'm not asking for much. My teacher's already out of work. Thank you.
Thank you. Thank you all very much. Carney versus Metropolitan Transportation. I'm just going to give you a few minutes since you're on your own today, okay?
Yes.
Good afternoon.
Absolutely. May it please the court, Tim O'Shaughnessy, MTA Law Department for appellants. It's clear that the plaintiff's motion was late. Statute provides that the complaint must be dismissed unless there's sufficient cause. This court has held it's sufficient cause. Requires a showing of reasonable excuse. Plaintiff didn't have a reasonable excuse. She moved to North Carolina in March of 2019, but she did not, in her own words, start taking care of an elderly family member full-time until the spring of 2020, an entire year later. Furthermore, she gave us an excuse, something about the court having problems with receiving mail or filings, but that's no excuse.
She served you by mail pursuant to CPLR 30, or she said she did, pursuant to 312-A. Now, a couple of the defendants were not even served in that manner. Two of the defendants did get the summons and complaint. However, as you probably know, CPLR 312-A requires there also to be service of an acknowledgement of receipt, and that must be mailed back before service is complete, correct?
It's all correct.
Did that happen?
Did not happen. We didn't receive the statement of mailing and acknowledgement of receipt. That's the
mail it back either.
That's the point two, actually, that the service of process was ineffective. But what I was saying was that she just didn't make the motion and didn't mail the papers to the court because of it's unclear what she was told by the court. And she also never explained why then she decided that it was time to make the motion. So we submit that the complaint should have been dismissed for two reasons. Thank you.
Thank you. Have a nice afternoon. And finally, we have People versus Nahal Modi. Good afternoon.
Good afternoon, Your Honors. I'm Mark Baker on behalf of Nahal Modi. This is a very fact-specific case, and the prosecution, in order to elevate a civil case into a criminal matter, had to establish two crucial elements beyond a reasonable doubt. It needed to prove beyond a reasonable doubt the defendant falsely stated that Costco was a customer, and it had to prove that he intended to permanently deprive the complainant of their property, the monies that were owed. I submit that as to both of those issues, the testimony alone of prosecution witness Jonathan Mitchell warrants a finding that those burdens would not have met. And I ask the court to review in its consultation pages 243 to 277 of Mr. Mitchell's testimony. As to the false element, false representation element, Defendant had every reason to believe what he was saying was absolutely true. He had,
Did he have a direct relationship with Costco, sir?
he had a collateral relationship.
Oh, did he disclose that collateral relationship?
No,
I know
he did not.
I know he gave an explanation for it, but was that disclosed?
No, it was not, but it was, he said that he supplied Costco. Now, Mr. Mitchell, in his testimony, item after item, discussed how, when you're talking about High Mountain, LGDM, and Unique, they were all registered customers of Costco, which defendant did business with. And in defendant's own testimony,
So the defendant did business with actually,
selling Costco through those entities.
no, did business with these entities who then presumably sold to Costco, correct?
That was the expectation.
And his explanation for that was that he didn't want the victim, I guess, or
He didn't want to be cut out.
yeah. Now, the jury heard that, correct?
That's correct.
And made a credibility determination?
They made a credibility determination, obviously, but this is a second jury, and I'm asking you to look at it differently. I'm asking you to look at the fact that in his testimony, Mitchell talked about how defendant and he discussed how each of these entities could be the source for reselling it to Costco. So Costco was ultimately to be the buyer. And that defendant in his own testimony talked about Unique, which he had in fact sold to Costco. Now, you raised the point.
Now, you'd be on stronger grounds, wouldn't you, if in fact your client wasn't obtaining diamonds and then immediately pawning them, and I know you redeemed them, but there was a lot of moving parts going on at that time.
Yes, but in the end, first of all,
Did your client,
with respect to.
hold on a second. Did your client, for example, tell the company that he intended to actually pawn the diamonds for half their value?
He did not have to. He bought those on.
Those were memos. Weren't those on memos?
No, those weren't memos. Those were,
Well, that's
those were
a
invoiced.
question. I mean, your expert said that they were
They were-
invoices,
that's
but the plaintiff, I mean, the people did not think that they were invoices, that they
think
were
that-
memos.
I don't think they rebutted our expert, and that's where reasonable doubt comes in. The fact of the matter is, he redeemed each of those 11 diamonds, and the money ultimately was given to the extent that he had it to give it to the complainant. Now, as you say, Judge Singh, the district attorney is going to tell you, but he didn't do it directly. And when I was reviewing this matter yesterday, it occurred to me that if this were a perjury prosecution, and this is the Bronston case that I called up, I emailed my adversary to look at. Bronston versus United States was a perjury case. If this had been a perjury, he'd be acquitted as a matter of law. Open quote, the cases support petitioner's position. The perjury statute is not to be loosely construed so long as the witness speaks the literal truth. I submit, and the burden is on the questioner to pin the witness down to the specific object of the questioner's inquiry. I submit that here the defendant indeed spoke the literal truth. He was never asked, are you a direct customer with Costco? He was asked, do you supply, which he did, but he did it through Unique and through High Mountain and through another entity. Now, with respect to the issue of intent to permanently deprive, again.
Also, before you move on to that, I mean, could Unique accept or reject purchases on behalf of Costco? Could it do that?
Sure.
There's evidence of that?
But he had, he testified, defendant testified on pages, give me 1 minute, 577, 585 to 586, that he in fact had sold to Unique in the past, who then in turn sold to Costco. So the fact of the matter is, there's no reason why he didn't have a right to rely upon that relationship. There was nothing to dispute it, nothing to suggest he didn't. With respect to the intent to permanently deprive, defendant had Mr. Mitchell go to LDD several times and make several offers to them. He told Mr. Mitchell, I have this debt, you've got to help me. But I think the most incredible offer he made was defendant and John Mitchell were putting together a business called Excelsior Capital Venture Capital. It was to be capitalized expectedly to the tune of $10 million. Defendant told Mitchell, go to Gavriel and tell him I'll give him 65% if he goes along with this and takes this in lieu of my otherwise ability to redeem the debt. According to Mitchell, if LLD had been involved and it succeeded, all defendants' debts to that company would have been satisfied. That's at page 266. The fact of the matter is that when you add that to the efforts of bringing additional diamonds to LDD, which they accepted, another offer of a $400,000 value, which they did not accept, the fact of the matter is, on this record, all just from Mitchell's testimony and all the offers the defendant made through him, there was not intent to permanently deprive. The only intent the defendant had with each offer was to make them whole. It was the result of his business reverses and his inability to achieve.
But wouldn't pawning jewelry for, I don't know, 50% of its value suggest, or a jury could infer, in fact, that there was an attempt to permanently deprive LLD of those diamonds?
He had a right to pawn. Did he make he said that sometimes it's good business to take it at a loss, because then you're still ensuring that you have this as a customer.
Well, he sounded like he was taking a lot of losses. He was selling all kinds of jewelry for undervalue.
He was in over his head, according to Mr. Mitchell. There's no question. He was having personal issues. But the point is, he even at some point gave them 10, according, if you look at the, I think it's page 11 of the brief, there's a chart of all the payments made. There was a whole series of $1,600, $3,200 payments. These were 10% of his salary that was being garnished, not garnished, he's offered to make them whole. The point is, when you're talking about intent to permanently deprive someone of property, and you have all these efforts to demonstrate that you do not have that intent, but you in fact have the intent to make them whole to the best extent possible, it's not a crime. Did LDD have a civil application to make, a civil complainant? Absolutely, but not criminal. The burden is too high. It was not met here. Thank you.
Thank you, Mr. Baker. You'll have a few minutes on rebuttal.
Good afternoon, Emily Galt on behalf of the people. There's no doubt that defendant intentionally stole over $1 million worth of property from Greg Soviet. This was a question for the jury who heard the evidence, they heard defendant's testimony, and still chose to reject his account. Simply stated, this was one big scam, and regardless of whether defendant made any payments back, doesn't change that. Defendant obtained 60 diamonds valued at $2.6 million from Greg Soviet based on a repeated lie that the diamonds were going to Costco.
Well, what about your adversary's point that in fact they were going to Costco, or at least some of them were going to Costco, and it was your client's, it was not your client, excuse me, it was LLD's obligation to inquire.
Well, no,
Direct, indirect, for example.
So we know where 31 of the diamonds went, and they were not to Costco. They were not to High Mountain. High Mountain had a business relationship with Costco, but High Mountain had a business relationship with Costco, and it had a subcontract with one of defendant's businesses, Aston. That ended in 2014 before any of these transactions took place. And also those involved fashion pieces, which were diamonds under 1 carat, and every single diamond that defendant got was over 1 carat. Defendant repeatedly said that he had meetings with Costco, that he was meeting with them, he had phone calls, he was saying that this is what Costco wants, he was sending emails referencing Costco. In reality, that didn't exist.
I mean, didn't Costco, I think someone testified that they didn't have his email relation, that they had no relationship.
Yes, so in order to
Didn't know
sell
who he
to
was.
Costco, you have to be a vendor. You have to be a registered vendor, and you have to have a vendor number. Defendant didn't have that, nor did his company, Noble Titans, have
Well,
that.
did Unique have it?
That is not clear from the record, that the Jennifer Mitchell, or I'm sorry, Jennifer.
But that's their point. Their point is that it was done, it was done through intermediaries, and therefore there was really never an intent to defraud, intent to lie.
But, Your Honor, defendant never told Greg Soviet that he was selling to Unique. He never said that there was this business in between. And defendant made clear that, he, for his own intent and purposes, Unique was Costco. When he was saying Costco, he really meant Unique. But at the same time, he said that Unique couldn't even make decisions for Costco at the end of the day. At the end of the day, Costco had the authority to say yes or no. And also at the same time, defendant said he purposely wasn't telling Greg Soviet about these other companies because he was scared he was going to lose business. So this was very clearly intentional. He planned on defrauding them. Again, he immediately turned and pawned these diamonds for fractions of the prices just so he could get quick cash. And additionally, his own expert testified and said that defendant had told him, Peter Montablano, during an interview that defendant represented to Peter that he was telling the Soviets that all the diamonds were going to Costco. His own expert said this. So clearly, this was fraud. And ultimately, this was a question of fact and credibility for the jury, and the jury's finding of guilt was compelled by the evidence here. If your honors would like me to address the other 2 points in the brief, I'd be happy to do so. If not, we rely on our brief. Thank you.
Seem to me no more questions. Thank you.
Thank you.
Even if you accept the premise that this was a false statement about his relationship with Costco, which I submit is belied by the record, and all the entities that he dealt with, there's no answer to what I've suggested to you was no intent to permanently deprive them of the money. All the evidence points to the fact that defendant was, excuse me, was actually trying to do cartwheels to make them whole. The fact that he wasn't able to in the final analysis, despite efforts to do it.
But does the subsequent restitution attempts, does that negate intent to commit larceny at
No.
the time the diamonds were obtained based on false representation?
If restitution came as an afterthought, absolutely not. It would not undo a conviction. It would mitigate sentence, perhaps, and I think the judge did that, although I think it's still excessive, and I ask for a further reduction. But I think the facts demonstrate, with his constant discussions with Mitchell, and that's why I gave you those, just that testimony to read. He did everything he could to try to make them whole from the get-go. It was not an afterthought. He knew he was behind. He tried to figure out ways to make them whole. He just wasn't successful in the end, but he did the best he could. Thank you very much. I'm sorry? Yes, that's the testimony I'm asking you to read. Thank you very much.
Thank you. Thank you both, and have a nice afternoon or evening.
Thank you very much. Want to take my earphone or bring it into? All right. God send this thing.
It helps you out. I'm glad it helps you out, sir.
I thought you were going to consent. I don't know.
Good night, folks.